Good morning, everybody. First of all, I am not Judge Michelle Reck. She'll be out in a little bit. We're doing something slightly unorthodox today. This panel will sit for the first two cases, and after that, we'll take a short break and we will reconfigure with Judge Rick as the presiding judge. I am Chris Yates. I'm glad to be with all of you here this morning, and I'm especially glad to be here with my colleagues, Judge Mariani, who's been sitting with us all week, and Judge Wallace, who generously agreed to join us for these first two cases. I would give you the admonition about not mentioning names of any children or victims of crimes, but I don't have to do this because both of these cases do not involve any of that. So I'll give you the basic instructions. You have a half an hour per side. If you are opposed, if you're unopposed, you have 15 minutes. If you want to reserve some time for rebuttal, please let me know, and I will be more than happy to accommodate you by keeping an eye on the clock. And with that, I think we're ready to begin. Our first case this morning is numbered as 6. It's docket number 372652. It's the case of M1 Transportation LLC against Liberty Mutual Insurance Company. And I believe we have attorneys endorsed on both sides of this case. So whenever you're ready, counsel for the appellant, you have 30 minutes to divide up any way you like, and you may begin.
Good morning, Your Honors. May it please the court. Jonathan Akari on behalf of the plaintiff appellant M1 Transportation LLC. This matter is a second level of appeal for this case. Previously, Liberty Mutual had appealed this to the circuit court successfully, leading to our appeal. And I think to understand our grievance with that decision, you have to start from the beginning in the district court with this matter. And it begins with us filing a provider suit for allowable expenses in the 19th District Court. Liberty Mutual in December of 2023 files a motion for summary disposition asserting that the underlying patient, Mr. James Fry, had elected to opt out of medical benefits per MCL 531.07D subsection 1. And in support of that motion, what Liberty presented was 3 documents. First being in this, I could give our exhibits. Our exhibit B.
I will indicate for you, it was a real challenge trying to figure out what's in the record here because we only get the record from the circuit court. And the only copy we have of that motion does not have the exhibits attached to it.
Sure.
We think we know what the 3 exhibits were, but we don't know. So if both of you could illuminate us on that point, it would be very helpful to know what was in front of the district court.
And to compound things, Your Honor, this morning I discovered our exhibit A is actually not, at least to our brief on appeal, was not the initial motion for summary disposition. It's labeled as such. It was actually the motion for reconsideration, as I saw in the introductory paragraph.
But we have that in the record.
The original summary disposition motion?
Well, the motion itself, yeah.
Sure. There are 3 exhibits to the initial motion for summary disposition would be the declarations page for our policy period of January 2022 through January of 2023. Much of it is redacted.
Including the premiums.
Including the premium section. There is an indication on page, bear with me for one moment here. Page 4, there is an indication that one or more of the insureds under the policy have been excluded from personal injury protection benefits based on the availability of qualified health coverage. So that would be one of the 3 exhibits. The second would be a form policy. nothing really extraordinary in that document. Much of it refers to elections reflected in the declarations page, which was mostly redacted. And the third exhibit, which at the time we found quite interesting, was a correspondence from Liberty's adjuster named Lourdes Lopez to Mr. Fry dated May 15 of 2022, indicating that the policy was not an opt-out, but in fact one for coordinated benefits, and indicating that in the event it was improperly coordinated with a Medicare plan, that it would be unlawful to have Medicare act as the primary payer.
But I think if, as the record developed, it turned out that it wasn't a coordination.
And
It was an opt-out.
And it was the series of events that led to the appeal and our appeal. Because our response was that, one, we pointed to the letter saying that, well, that kind of muddies the waters here.
Right. But the denial letter can't recharacterize what the opt-out was, right? I mean, they may have made a mistake. They may be wrong, but that doesn't change the nature of what the policyholder did.
Can it reform the policy?
It cannot reform the policy, Your Honor, but our position was that they hadn't established prima facie proper opt-out. Our argument in the district court was.
I think we completely understand what your arguments were, but here's my question to you. Let's just say we agree with you. We say, okay, right, the circuit court shouldn't have done what they done. We reverse the circuit court, reinstate the district court's order. You go back to the district court, you go to trial. Liberty Mutual is going to introduce at trial the opt-out page along with the rest of the insurance documents, moves for a directed verdict. How do you have any response to that that's going to result in anything other than the case getting dismissed?
So a big problem with this case, and I could tell you that if from the outset, this could have probably been resolved with a simple email. Here's our proofs, here's the qualified health coverage, here's the election form, and we make a decision from there. The 19th District Court issues an order in every civil case.
We've seen it. 56 days, you have to produce the claims file.
Incorporating the court rules, including Court Rule 2.313C1, which states that, and I'm not sure if it was cited in our brief, I cite this rule almost on a daily basis, Your Honors. In trial court, it's often the case that you get smoking gun evidence that's now pulled out until months into a matter, sometimes right before trial. And something like this, it could be totally dispositive to the entire case. And we respond, well, you had an obligation to disclose. And the court rule says, unless you have a real good reason for not disclosing evidence, material evidence, you can't use it on a hearing or at trial.
Well, let me ask you this. Are you arguing that the PIP selection form is now inoperative, or that it's just out of play and they can't use it even though everyone knows it exists?
What we are going to argue is they cannot use it to establish an effective opt-out. And
as a discovery sanction or what?
In part as a discovery sanction, but it's our position.
Discovery sanctions generally are supposed to be calibrated to the severity of the violation and the continuity of the violation. And I don't think you have either one of those arguments to make here. The first option is not to take away a critical piece of evidence. The first option is impose attorney fees or something like that, not change the whole outcome of the case.
Well, and I think you're right. It's a case by case basis. In situations like this doesn't just alter the trajectory of the case. It completely obliterates the entire claim.
Right. It's right. And I'm glad to hear you concede that, because if this document can be considered, you have no argument, right?
Agree. And that's exactly why it's our position. You have to play your cards from the outset. And I think that's what the rule is meant to, the court rule, as incorporated in the 19th District Court's order, is intended to do. Lay your cards out on the table so that the parties and the court doesn't have to waste their time with litigating these matters.
But when you get the deck, when your client gets the deck sheet and it says there's an opt-out, again, you talked about emails earlier. How come there's not an email to defense counsel saying, wait a minute, where is there a form that's been signed by the insured here? Like, why didn't that happen?
Well, it's often the case. So it's their defense to establish, and they lead off. Well, they don't lead off. The case was several months into litigation at that point. We don't hear from them. And when the first thing we hear is the form of their summary disposition motion in December. And at that point, we filed the case. We've done our disclosures. I'm not sure if a pretrial conference has occurred at that juncture, but we don't know until we're told this is an opt-out in most cases.
But by the time you get the motion for reconsideration in the district court, 2 courts back, you're dead in the water, right?
Well, at that
Now,
juncture,
at that point, I know you've got procedural arguments to make, but if that document can be considered, you're dead in the water.
if it can be considered, I would have to agree with you.
All right, so my point is, this thing's been dragging on now from the district court to the circuit court to the Court of Appeals, and then Judge Wallace points out if we go along with your argument, the natural result is you two are going to wind up having to try this case, and that's when it's going to be decided.
And I think that's where the discovery issue will be decided as well.
Discovery rulings are pretrial. I mean, you can't. No judge in his or her right mind would leave this to go to trial with the discovery issue hanging out there. And I, with all due respect, I can't imagine how any judge would be allowed to exclude this critical document as a discovery sanction when there's no history of discovery violations in this case.
Well, they didn't produce anything else at all. Judge Summers ordered the entire claim file. All we have is what was attached to their initial motion and the motion for reconsideration. I don't know how large the claim file is. I don't know what else this far out is in the claim file. It's very possible that there's some additional information that I'm just not aware of. It might be the case that there's a non-qualifying resident in Mr. Fry's residence that would arguably disqualify him from an opt-out under the statute. We don't know.
Well, why don't you talk about that a little bit? How does that play out?
Well, I'm sorry, Honor, which aspect? The claim file or?
About there being a non-qualifying resident relative in the household.
So it wasn't briefed, and I will say I'm not prepared totally to argue that, but the statute, from my understanding, 53107D requires that the insured and all household relatives be qualified for this purported election, an opt-out based on qualifying health coverage. That means they all either have to have Medicare or, and I believe the private coverage requirements are, it can't exclude auto coverage and the deductible can't be larger than $6,000, something along those lines. That wasn't argued previously. Again, I have no idea what other claims documents Liberty may have. It just, nothing other than the attachments to the original motion were disclosed, which is why we responded in the manner that we did. Then the additional documents substantiating the alleged opt-out came on recon. And
Counsel, I mean, I guess is your point that, to the extent there is a discovery violation, it's bigger than this one piece of paper.
yes,
And what happens if you win is you go back and you take it up with the district court, how to handle, I guess, that claimed violation, to size it up and decide what remedy, if any, is appropriate. So
exactly, Your Honor. It would be more fully developed what we would argue in the district court. It's a shame. We might have been able to preserve the argument on appeal. This is all kind of hypothetical on what happens if it gets sent down. We probably could have argued from the outset, none of this was disclosed. Not even the insufficient proofs initially submitted in support of summary disposition. We did not. Nevertheless, the motion was denied as unsupported. Then on recon, the additional documents came out. We don't get a response on recon. And it's something that I've been trying to keep in mind, both in the initial appeal and on here, that there is a disclosure requirement in the district court based on Judge Summers' order there. And there's going to be repercussions for that if we get sent back down to trial court. I think our argument as to the error in the circuit court is pretty clear to your honors. I'll just reiterate that the circuit court was sitting as an appellate court, and as you well know, it's an error reviewing court. The decisions that were appealed were the summary disposition denial and the recon denial. Standard review for the first is de novo, and the standard review for the recon motion is abuse of discretion. I think what I've just previously said makes clear the basis of the 19th District's denial of the summary disposition motion just as unsupported. When it came to the order denying recon, I think it bears just reading the literal words that Judge Summers issued in his order. And what he says is defendant seeks reconsideration of the court's February 2, 2024 order denying summary disposition. The motion does not demonstrate or even allege any error. Rather, defendant presents for the first time a document, Exhibit C, purporting to be electronically signed by the named insured excluding PIP coverage. The original motion's Exhibit C was a blank document with no signature page. I believe that was actually the deck page, but he goes on, there being no demonstration of palpable error based on the record presented, the motion for reconsideration is denied. And then he adds some other arguments that weren't addressed. On appeal, the circuit court took that statement and, in my view, your honors, completely turned it on its head to say that, well, yes, on appeal, we only deal with the record presented on summary disposition, and it is within the district court's discretion to disregard new evidence presented on recon that was perfectly available to the moving party on summary disposition. However, the circuit court took that statement and interpreted it as Judge Summers considering the document. And I think that is the error that led to this appeal. I think it's very plain in the order that Judge Summers was stating what he was presented with. He's very detailed. He doesn't do oral arguments. He decides on the brief. So he issues these written orders that on recon, I'm being presented for the first time with this election form that was not presented on summary disposition. That is not palpable error. I don't have to consider this. And he was well within his discretion to issue an order like that on reconsideration. Circuit court interpreted it as he considered it, opening the door for me to peek behind the veil, so to speak, and consider it. And obviously, as we just went through, if you consider it, then you have to dismiss the case. But that's not within the purview of the circuit court. The circuit court was acting as an appellate tribunal. The judge's role there was limited to reviewing the 19th district for error. I see no error with anything that the 19th district court did. And on appeal, I think and we cite the case law, considering post-summary disposition evidence was outside of the purview of the circuit court as an appellate tribunal. And for that, your honors, we think the circuit court needs to be reversed.
And sent back for further proceedings consistent with our opinion? I mean, it's really frustrating because the last thing we want to do is send it back, go through all this again, or go to trial, as Judge Wallace says, and then you're all spending thousands and thousands and thousands of dollars to get to an inevitable result unless you can somehow convince the trial court that this dispositive document can't be considered.
And I think further proceedings might be more appropriate for the district court. It might be the case that...
Right. It would have to go back to the district court. The circuit court can't fix this mess.
And I think we can argue there whether the production of the complete claim file or the failure to produce makes it a more egregious discovery violation than just failing to produce these documents. It's my position that when you have a smoking gun like that, it really should lead off everything. And, you know, I think the district court would be in a better position to say where we were at the case when the motion was filed. Should we adjourn the deadlines that were set in my order? And we could argue how to proceed from there. I don't think, and it's just speculation, I guess, but I don't think it will immediately go to a trial date. I think once we go down there, we can reconvene and figure out where to take it from there.
Did the defendant's affirmative defenses argue that there was a PIP opt-out?
Offhand, Your Honors, I
Okay.
do not know.
That's
You've used up quite a bit of time. If you want some for rebuttal, you probably should stop there.
Thank you so much.
Thank you.
Thank you.
May it please the court. My name is Simone Kapadia and I represent defendant appellee Liberty Mutual. As this court has noted, this PIP opt-out selection form, which was attached for the first time on reconsideration, is dispositive of M1 Transportation's claims in this
Right.
case.
Opposing counsel concedes it's
Yes.
dispositive. So the question is, why did the record get so messed up?
So I will say that in support of Liberty Mutual's initial summary disposition motion, the policy was attached. And in the policy, it references that PIP benefits have been removed. It has a warning that says one or more members on the policy do not have PIP benefits on this case.
And your view about the letter concerning coordination should just be completely disregarded.
That is
I
correct.
mean, it's obviously wrong, but
That is correct. The letter cannot change the terms of the policy. And considering the terms of the letter to change the terms of the policy is an error as well.
But in terms of what the trial court did, let's unpack that just. I think you would concede that the trial court should have denied summary disposition in the first instance based on what it had in front of it and what it didn't have, right?
So our position is that the policy.
You don't want to try to win on that argument, do you?
So
You've got a showstopper here.
and even regardless, I think the real. I agree. I think that the fact is that ultimately when the PIP selection form is presented on reconsideration, any other decision besides.
Okay. So then the question is whether the district court properly considered the additional evidence. Now, it is within its discretion to do so, but it's not clear that it did consider the additional evidence, is it?
I would say that they did. And the reason for that is because the trial court and the district court's order explicitly says, it describes what the document is. It says it's a document with the defendant, with the claimant's signature.
I mean, counsel, if I'm a court and I'm saying I deny this motion for reconsideration because you have attached new evidence. The fact that you attach new evidence, namely this, the fact that I named it now means that I have substantively considered it in reaching my decision despite me saying otherwise?
Well, when it's dispositive of the plaintiff's claim, it is.
Why is that?
Because it's an abuse of discretion to not consider a dispositive document like that.
Where's the authority that says I
There's an
have to
unpublished-
consider a dispositive document that has not been submitted in a timely fashion?
There's an unpublished case that I cite in my,
So where's the binding authority?
the unpublished case cites to, I believe, George versus Allstate, which talks about the fact that declining to exercise discretion is an abuse of discretion. And so in the case where it is my view that the trial court reviewed this document, saw that describes what it is, and then says that it is not dispositive of this case. And then the trial court it says that there's a question of fact regarding this. So when you have an error of law, it is an abuse of discretion. And that's ultimately what this comes down to.
And the error of law here is what?
Is that the PIP opt-out selection form is a dispositive form that indicates that Mr. Fry did not have PIP benefits through Liberty Mutual, which means that M1 Transportation, as Mr. Fry.
Why was it not attached to your motion for summary disposition?
I think that maybe it should have been, but I think that ultimately it was attached.
But why wasn't it? I guess that's my question. Do you have an answer? Or no?
I do not have an answer for that.
It seems to me, though, you're turning reconsideration review on its head. Because let's remember what reconsideration looks like. They have no opportunity to respond. They have no opportunity to present oral argument. In the court's discretion, it can allow it, but neither one of those things is required. And you seem to be telling us that even though reconsideration just is about whether there was a palpable defect in the underlying ruling, that there's this weird exception that if something's really important, that the entire principle of reconsideration gets turned upside down. And it's an abuse of discretion not to consider something when reconsideration never involves considering new evidence.
Well,
I mean, that's a crazy approach.
Well, I think that when it is dispositive of the claim, that it is an abuse of discretion to not consider that. And I would also direct the court to, I believe it's Hughes versus Kaspari, which talks about the fact of disregarding particular affidavits that are dispositive of a claim. It would be considered an abuse of discretion.
But it was a jurisdictional issue, wasn't it?
That was a jurisdictional issue. That's correct.
Wait a minute. I mean, let's assume that you submit something and you say, this is the opt-out of PIP. And his argument is, no, that's not my signature at all. I didn't sign that. How is he supposed to even make that argument in response? You presented something you claim to be a dispositive argument. He has no opportunity to file a brief in response. He has no opportunity to make oral argument. So the court just have to take it at face value and say, but there you go, you win.
And also no opportunity to determine whether there's a non-qualifying resident relative that would have basically made this opt-out obsolete.
So one thing that I will say, if I may, to answer the multiple questions, is that first, in Liberty Mutual's answer to the complaint, I believe it's paragraph 4, we put the plaintiffs on notice that there was an opt-out at issue here. And furthermore, if the plaintiffs are arguing that, yes, I agree that under the court rules, a response to a motion for reconsideration is not allowed. But there's nothing precluding the plaintiffs from filing a motion to strike. This document is part of the record on appeal, and it's part of the record at the district court. If the plaintiffs had an issue with Liberty Mutual attaching this document at the reconsideration stage, they had a redress at the trial court. They did not take that up. And at the point, the simple fact is that this document is part of the record on appeal, and it is dispositive of M1 Transportation's claims in this case. And I would also direct the court to the language of the PIP opt-out selection. I believe it's this, the self-certification on the PIP opt-out selection is that by selecting option 6, you certify that both of the following are true, as in Mr. Fry, the claimant, certified. The applicant or named insured has coverage under both Medicare Parts A and B, and all family members have qualified health coverage or are covered under another auto policy with PIP medical coverage. So that's Mr. Fry's self-certification that he is saying that there is. And I would also note that upon my review of the policy, Mr. Fry is the only insured on the policy.
But isn't that part of the reason why Judge Summers would have a standing order for your client to produce the claims file within 56 days so that counsel for the plaintiff can look through and find out, guess what? Maybe the insured wasn't honest in the application for insurance. Maybe there was somebody else living there that didn't qualify, thereby nullifying the opt-out, right? But you didn't produce the claims file, so he had no opportunity to look into any of that. Isn't that true?
So, Your Honor, I'm not privy to what was or wasn't produced within discovery at the parties. I will say that I think that they're correct that the PIP opt-out form was not produced until the reconsideration motion. I'm not specifically sure as to what else was.
So you can't even tell us as you're standing here right now whether there was a non-qualifying relative living in that household, right?
I wouldn't be able to. My understanding is no, but I would not be able to say it dispositively one way or the other. But there's no reason.
Part of the reason why you don't know is because the claims file is not in the record because your client didn't produce it within 56 days or at all.
I wouldn't be able to speak to what was or wasn't produced during discovery.
Well, play this out. How do you want this to end? Because I think opposing counsel is arguing that we should reverse the circuit court's determination, remand for further proceedings consistent with our opinion, and let it all sort itself out in front of the district court. I'm sure you don't agree with that. How do you want the order to read in this case?
I think
just affirm the circuit court?
Yes, Your Honor. I believe that this court should affirm the circuit court because I think that the circuit court's ruling was correct. Is that this this opt-out form is dispositive. And I would also say that none of the arguments that were made this morning regarding perhaps what may be happening on a remand were not really addressed in depth in the briefing as well.
Well, how could he address it? He didn't have the right to file a reply to your motion for reconsideration.
Or in his appellate briefing. It's not really, he mentions that it's, that this document, but I would say that this document, there would be an abuse of discretion to disregard the PIP opt-out selection form. And again, there was no motion to strike at the district court. There was no really,
But he wouldn't be able to strike at this point. I mean, his argument, I think, is that we just can't consider it, period, end of story. He concedes that if the trial court consider it, or we can consider it, he loses, you win.
I mean, I agree that, and that would be my position as well, is that I think that this document is dispositive of M1 Transportation's claims in this case.
Well, couldn't we just remand to the district court, have the district court order your client to produce the claims file? And if it turns out there isn't a non-qualifying relative living there at the time, at the subject time, and there is a PIP opt-out in the file, then you would win, right?
That would be this court's discretion. I think that would be unnecessary, but given that there is this PIP opt-out selection form, and then the selection itself talks about the fact that there's a self-certification regarding other family members in the PIP selection form. So I would say that the requested relief in this case from Liberty Mutual would be an affirmance of the circuit court.
This is why I want to make sure I understand your position correctly. In terms of the district court's abuse of discretion on the motion for reconsideration, is it that it was an abuse of discretion not to consider, to just not consider the document because it was dispositive? Or is it that the district court considered the document, and having considered it, it was an abuse of discretion to not? Which one is it?
I would argue both. I think that first, my view of my reading of the district court's reconsideration order is that it did consider this document and arrived at the incorrect conclusion. But even if this court disagrees with my view of the reconsideration order, it would still be an abuse of discretion for the district court to have disregarded this dispositive document.
It's that the published case you cited before.
I believe it's the unpublished case that there's an unpublished case of Detroit. I'm forgetting the full name of Detroit that cites to, I believe, going off of memory, George versus Allstate. I believe also Use versus Kaspari talks about the affidavits.
That's all your brief.
Yes, that's
Okay. Oh, thank you, counsel.
and unless the court has any further questions.
No, thank you.
Thank you
Oh,
very
thank
much.
you.
So much. You have 5 minutes to rebuttal if you want. Mr. Akari, whenever you're ready, you may proceed.
So I guess, Your Honors, just a few points I want to emphasize. First, in terms of whether or not the post-summary disposition evidence is in the record, it's not. I think the case law we cited is quite clear. You have to review the summary disposition decision based on the evidence presented in the trial court.
What's your response to her argument about George v. Allstate?
George v. Allstate, I had a note on that, and the issue there was whether an argument was preserved for appeal. I think that's a little different. From what I remember of the case, there's dispute over coordination of benefits with an ERISA plan. I think at the summary disposition stage, everybody was well aware that was, from what I remember, that it was an ERISA plan. Certain arguments were not made at the summary disposition stage, and on recon, additional arguments were made. And that's why the Court of Appeals decided that the arguments were preserved. I'm not quite sure that that was a matter of whether evidence was in the record. And in terms of whether notwithstanding the fact that certain evidence wasn't presented at the summary disposition stage, that the new evidence is just so explosive that it blows up the whole case on recon, that alone is error, I think, and it's an unpublished decision, but I think a state of OD show cited in our brief dealt with something similar. It was a rescission issue, and there was a question of whether or not the insurer's tendering of the check had been negotiated by the insured. They had presented on summary disposition, if I'm remembering correctly, a copy of the uncashed check, and it was argued that there's no proof that it was ratified by the insured by negotiating the instrument. And then on recon, they either the adjuster had produced an affidavit confirming it had been, or they produced the cash version of the check. I'm a little muddy on the facts here, but that similarly would have blown the claimant's case to pieces. But the fact that it was such strongly dispositive evidence that was withheld until the recon stage, that did not obviate the trial court's discretion in declining to consider that evidence at that stage. And I think the last point,
Is that one published?
that is an unpublished decision. It is attached to our brief. And I think the last point I want to make with regards to the letter that the adjuster sent, it's not that it alters what the policy is, but it's a matter of what we knew.
You're talking about the one on coordination, the
Yes.
letter on coordination.
Yes, from Lourdes Lopez. It's not that it alters what the policy is, but it illuminates what we knew at the summary disposition stage, and what we had in the declarations page. I mentioned at the start of my argument, page 4 included a warning. What I didn't read was the second part of that warning, which is you must obtain coverage for PIP medical benefits for such persons, that would be the excluded persons, within 30 days after the effective date of the termination of QHC for the persons, or they will not be entitled to any PIP benefits under this policy. And they cite to 3107D, which involves Medicare and qualified private insurance opt-outs. But and I need to double check this, but the statute MCL 53109A, which I believe does deal with coordination of benefits. And at that stage, without knowing anything else with the record presented, there is a question of whether or not it was improperly coordinated with Medicare versus an opt-out under 3107D. And that's all I have to add.
Thank you very much.
Thank you so much.
This case will be submitted. We will now move on to case number 16, docket number 371355, Demetrius Burks against Liberty Surplus Insurance Corporation. And I believe that counsel for both sides will be appearing remotely. So,
That is not correct, Your Honor. It is only counsel
Oh.
for the appellant.
sorry. Okay, sorry.
Leave to
Okay.
attorney.
I got it. Okay, right. I saw two grants. Okay, so let's make sure we have everybody on board before we begin this argument. Mr. Stone, can you hear us?
Yes, your honors.
All right, and just a second, I think you are the appellant, so you may go first. And I presume you're Mr. Van Gelderen? Thank you very much. So why don't we proceed? We can hear you perfectly, Mr. Stone, and you may begin whenever you like.
Thank you, your honor. I'd like take a moment to thank the other honors for their time also in hearing this appellant's argument with regards to Mr. Burks. Just a brief history. Motion for summary disposition was brought by defendant in this case. It was granted by Judge Hubbard. Oral arguments were held, and during oral arguments, I brought up a second point of defeating the motion for summary disposition. However, in this case, Judge Hubbard already had her opinion written. She read it from the bench. With regards to that, she ignored my oral argument with regards to the closed head injury and my arguments with regards to serious impairment of a body function. and how it's affected Mr. Burke's everyday life.
Well, I think, and I'm sorry, I don't mean to cut you short, but I think what we're just trying to figure out as far as serious impairment is whether the impairments were objectively manifested, right? That's where this case turns.
Well, not really. There's two arguments. Number one, whether it's objectively manifested, and we set forth a plethora of aggravation and existing aggravation cases because there's two accidents kind of close in time. And number two, that there's a serious neurological deficit that automatically defeats summary disposition, and which is perfectly stated in the IME report of Dr. Elmer.
Right, but that second argument is the one you say that Judge Hubbard did not consider because it came up only at oral argument, yes?
Correct.
All right, so.
Correct. Because
just
it
to
was
be
never
clear
even
about
addressed.
this-
I'm sorry.
Right, so just to be clear about this, if you look at the way Judge Hubbard reasoned out the case, it was a problem with a showing that the impairments were objectively manifested. But you would like to add to the discussion the point you made orally, but not in your brief, right?
Correct.
When
First,
I say brief, I don't mean your brief in front of us, obviously.
correct. And the reason why it wasn't in the brief to her is defense never even talked about this, and we were responding to defense's brief.
Counsel, I mean, as I read defense's brief, it talked about headaches. It said the only injury in the record was headaches, and there was no objective manifestation of that. That seemed to pretty squarely put the question of a head injury into play. And as I read the response brief, it just focused on the MRI reports for the neck and back that were taken right after the first accident. So I guess I'm not.
That is correct, but that's why we have oral arguments to supplement things, right? I mean, if she didn't request an oral argument, then why was I even heard in this case?
I'm not sure, counsel, if the point of oral argument is to, add new arguments. That I think part of the point of the briefing is to set the stage for what you're going to discuss at oral argument.
Well, if the defense would have brought up this exception to the rule, which is not anywhere in their brief, we would have addressed that. That is why I brought it up, because I didn't think Judge Hubbard understood that there's another component to this that she didn't consider that was not laid forth in defendant's motion. That's how this came about. Regardless, this person suffered a closed head injury by their own doctor and needs the exception, which is number 2 in our point, exception 531(2)(a) small double I, it fits the exception. Their own doctor says that. With regards to the first prong, which Judge Hubbard said there's no manifestation of an injury. If you read the case law with regards to exacerbation of old injuries, that's the manifestation. Again, that manifestation is in the IME reports and also head and spine and Mendelssohn's records. So she totally ignored all the language that the Supreme Court has ruled upon as to pre-existing injuries and exacerbation to them or aggravating the injuries. In fact, there's even when you go to trial, there is not court rules, but jury.
I think, counsel, the way I read her ruling was that not that she ignored the legal point, just that she didn't find an objective manifestation of aggravation. We had the MRIs that objectively manifested the injuries from the first accident that you're saying are aggravated. But I think as I read her ruling, she found a lack of objective manifestation of an aggravation of those injuries from the second.
That may be true, but she did not, if that's her ruling, but the record says otherwise. But then she never took into the close head injury portion of it. She never addressed it. Nowhere in the record is it addressed. She had her opinion written beforehand, and I wanted to clarify it on the record because it was never brought up earlier. And that's what it comes down to.
Well, to the extent you're relying on the closed head injury exception, tell us exactly what evidence you want us to look at to see if that's a sustainable argument.
Well, if you look at Dr. Elmer's report,
Doesn't the exception require sworn testimony?
At trial, yes. And Dr. is going to testify to his report. It's in a written form. This
But
is no,
in
Go on.
yeah, right. But in the statute, it says it creates a question of fact if there is sworn testimony. So why, I guess what in the record provides that sworn testimony? I understand you,
I don't believe it says sworn testimony.
or yeah.
Testimony under oath.
Testimony under oath. Yeah.
Correct. And there will be testimony under oath. This is his report. That's what they relied upon in theirs. There's no testimony under oath, but they relied upon it.
But they're not trying to claim the advantage of the exception.
Pardon?
I mean, they're not trying to claim the advantage of the exception, right?
No, but it wouldn't matter. If they rely upon it, then if it's not sworn testimony, why couldn't I rely on it? Because they relied upon it in their brief, stating Dr. Elmer said no. So they relied on it. I should be able to rely on it because Dr. Hubbard relied upon it. And if you go to his, I had it right up here, I'm sorry. Dr. Elmer, based upon your examination of your patient, your review of records submitted, your clinical experience, your research, was the painless condition caused by the May 2nd, 2022 accident. The patient's subjective complaints of headache, dysalirium, and dysfunction with cognitive were caused by the May 12th, 2002 accident. His complaints of neck, shoulder pain, and upper extremities, paresis, and back pain were an exacerbation of prior symptoms sustained in a March 22 accident. So if this doctor can conclude that there's a difference between the two, I don't know, and based upon his experience, his findings, his clinical experience, which are all objective, why didn't Judge Hubbard? It goes on to say, from a neurological standpoint, the treatment services and products are consistent with the severity of documented injuries and conditions. Estimated duration would be a period of 3 to 6 months afterwards. He also goes on status post motor vehicle accident of May 12, 2022 with mild cerebral concussion with headaches, dysalirium, and lightheadedness. Neurological sequelae of such expected to resolve within 4 months. Exacerbation of pre-existing cervical, lumbar, and shoulder and upper extremities with pain and paresis. This is all by their doctor, which will be at testimony at trial. So I thank you. Oh, also that he did receive household services and attendant care. Dr. Elmer concluded he needed those, and he got them from the PIP carrier. That was all paid as a result of this accident. So there was obviously something objective that their own doctor said that this person suffered these injuries. I don't know why Judge Hubbard didn't. That was her discretion, and we appealed. Thank you.
Thank you very much. You'll have time for rebuttal. Mr. Van Gelderen.
Good morning, and may it please the court. Ben Van Gelderen for the appellee, Ms. Bailey. First, I do believe this case turns on objective evidence of the impairment. That's frankly nowadays, that's the only prong that I will even bother to file a motion on, because all you need to do to create a question of fact about impact on life is provide testimony that his life was changed, which is present in this case. So the easiest.
If a physician diagnoses post-concussive syndrome, isn't that an objectively manifested injury?
It would depend on what the evidence they use to reach that diagnosis is. I don't think a diagnosis
Well, that
is
would be their
objective.
medical records and their examination of the patient.
Well, what are the I don't know of any examination findings that are objective that would reveal a concussion, but I think that certainly a doctor could say,
That's
yes.
the case. Do you know why your client's expert diagnosed the concussion here?
I don't, but I do know that he diagnosed a mild concussion, which
Which is a type of concussion, right?
Yes, which I do not believe constitutes a serious neurological impairment.
Well, but that's a different issue. So had the plaintiff had a affidavit from a doctor that said that was a serious neurological injury, then we wouldn't even be here talking about this, right? That
That's correct.
automatically gets you to a jury.
I would have withdrawn my
But-
motion.
But the lack of such an affidavit does not automatically give the defendant the right to summary disposition. It just gets treated the same as any other motion. You have to go through the process, determine whether there's an
Correct.
objectively manifested injury, and
Correct.
take it from there.
I do think that if our doctor's IME report said that I believe there's a concussion because when I did physical exam, I saw something in his eye, right? That would, I think, succeed because seeing something in the eye is objective, right? I don't believe there's anything in our report that is objective that led to his decision to say there was a mild concussion. And I think that's again, it turns on the objective evidence prong in this case.
That you read that it's based on the general.
Correct. Yes.
How about the diagnosis of paresthesia?
I don't know that the report contains objective evidence. of that.
He just read us from the report saying that upon examination, the doctor determined that the patient was suffering from paresthesia. Is that not an objectively manifest symptom?
It's an objective symptom. I don't know that it's necessarily an objective symptom of a serious impairment. And I don't know that the doctor necessarily related it specifically to the accident. I think that the easiest way to defeat a motion for summary disposition is to get deposition testimony or an affidavit from a treating physician, because then there's not even a question about it. So the issue always comes up when we have this case where there's no deposition testimony, there's no affidavit from a doctor. It's not required, but I think it's fair to scrutinize the evidence that they come up with to defeat that because they don't have either of those things. And so what did they come up with at the hearing? They came up with MRIs that were taken before the accident,
Right,
which I
right.
don't even think I need to address.
Yep, absolutely.
They come up with the IME, which again, I don't know that it connects the dots clearly enough to say, here's the objective evidence of a serious impairment that was suffered in this accident.
But if it's just a matter of degree and not kind, I come back to Judge Wallace's point. Why doesn't that create at least a genuine issue of material fact? Because, I mean, you described it, for example, as a mild concussion. As Judge Wallace wisely pointed out, well, that's a form of concussion. And it seems to me what you're arguing here more than anything else is degree. Sure, there's some objective manifestation, but it's not enough to get you.
I don't know that
That's
there's
something
any
else.
objective
Okay.
manifestation of a
Okay.
concussion in the record.
Okay.
That I don't know.
Okay,
I don't believe it's there.
okay.
As to this, the serious neurological injury exception, the statute does clearly require testimony under oath. That's not something that we see in statutes very often. I think the legislature used that language intentionally.
Right. And just to be clear about that, your view is that that is a standard that applies both at summary disposition and at trial, because presumably you get an affidavit. Now, that's not sufficiently, I think, necessarily testimony under oath. You could argue it is, but his promise is just wait till trial. We'll have that testimony under oath. Your view is Maiden versus Roswood and all sorts of things like that. You can't just promise to present the evidence. You have to actually present the evidence in response to a motion for summary disposition under C-10.
Correct. And I think part of that is because we run into these issues with the report where we're trying to interpret what the doctor said, and we're trying to connect these dots to say that what he says here, this is serious, this is a serious impairment and this is objective evidence. And if we have testimony under oath, that's clear, right? We nail this down and we have it. And I think the only other point that I wanted to raise is that there are records that were produced from Michigan Head and Spine Institute and Mendelsohn Kornblum. Those were only introduced as part of their motion for reconsideration. And it was well within Judge Hubbard's discretion to disregard that evidence that was coming to light for the first time in the motion for reconsideration. So I do think that the court's decision on this should be limited to essentially the IME report. So that's unless the court has anything further, I think that
Anyone else have any questions? Thank you very much.
Thank you.
Okay, Mr. Stone, you have some time for rebuttal if you want.
Yeah, just a couple quick, three things. The Michigan Head and Spine and the Mendelson Kornblum reports were all part of the first hearing. They were attached to their motion, and that was addressed. So whether I attached them, they were attached already, and that's why they were already in the record. Also, brother counsel brought up that you don't need objective evidence for concussion. Well, then concussions are out, right? You need objective evidence, and it's clearly stated in Dr. Elmer's report that based upon his examination of the records, what else did he say? That it is related to this motor vehicle accident. And then also, I can't get an affidavit from his expert. It's his expert. You want an affidavit from a treating physician? The problem here is the non-treating independent medical exam is the person who diagnosed him with this. So I can't call the guy up and say, can you give me an affidavit?
Right.
So it's hard to do.
Prevented from even contacting them.
Pardon?
I said, in fact, you're ethically prevented from even contacting.
Yeah, I can't exactly. Thank you, Your Honor. That's all, Your Honors. Thank you so much for your time.
Thank you both very
Thank you.
much. This case will be submitted. I want to thank Judge Wallace for sitting in on these two cases this morning. There's going to be a bit of a break now because the three of us will have to conference briefly on the two cases that have been argued so far. Then we'll be back out with Judge Rick in place of Judge Wallace. So be a little patient with us. As I told you at the outset, this is a little unorthodox, but we'll get through the morning. Thank you.
That's a fancy way of saying you just got rid of me.
Have a great day.
Hello, everyone. We've reconfigured. Thank you very much for your patience while we are now ready to begin at the top of our docket. Before I do that, I know that Judge Yates has already given instructions about the do's and don'ts. And for those of you who may not be aware, Judge Yates is going to be leaving the court in a couple months. And so if this is your last opportunity to argue before him, I would encourage you to enjoy that. He has been a gift to this court, to the people of the state of Michigan. Anyone who practices public service ought look up to Judge Yates for his compassion, his analytical skills, his writing skills. He's a poet, and it's evident every time his pen touches the paper. And he will be dearly missed, but we are grateful for the time that we have had with you, Judge Yates.
Thank you very much, Judge Rick. I really appreciate
Did
it.
you want to add anything?
Well, I mean, with all due respect to your presiding duties, I thought today was the day we say mean things.
Oh!
Yesterday.
Yeah, you were way too nice to me yesterday.
And I thought today was, but that's just for the record.
Okay. Did you want to say something mean?
Oof. Judge Yates is, he's too nice and thoughtful and smart, and it makes me look bad and I don't appreciate it.
Well, I wondered if you would all do me and the court and my colleagues the pleasure of giving Judge Yates a round of applause for all that he has done. And don't change your phone number because I
Oh,
have you
I
in my
won't.
phone.
Absolutely not.
All right.
I'll be easy to find.
Excellent. Good deal. Well, thanks again, folks. We're going to start things off with item number 12 on the docket, which is docket number 374775. In Ray Berriman Hurd, Morgan Hurd Minors, and I believe we have Mr. Walton here endorsed for argument. Good morning.
My name is Matt Walton, and I represent mother in this case. And excuse me. Ms. Morgan, Lita Morgan, she's the mother of 5 children. And her rights have been recently terminated. At the time of this accident, I'm going to call it an accident, one of the children got shot. Her sister had gotten arrested, and her sister's children were placed with her by the same foster worker that she has as part of a safety plan. Mother's, Ms. Morgan's home did not have a refrigerator or a stove. And 4 of her children at this time were in Florida visiting their godmother. So there were 5 kids in that house, but eventually 9. She went to one of the neighbors' homes to cook dinner. She didn't have a stove. Her husband was in the backyard with somebody else fixing a fence. And one of her sister's kids, 6-year-old, located a gun and shot her infant child.
Can you provide a little bit of factual context to this? Because as I understand it, when she left, she couldn't use the lockbox for the gun, so she put it up on some sort of high shelf.
And she did do that.
Have you seen a picture? Do you know what that looked like? I'm just curious about how far away it was and how difficult it was for the children to get to it.
There was no testimony as to that. It was my understanding was up high where the kids couldn't reach it, on top of the bookshelf.
Right. Somebody had to actually put chairs up or something to climb up.
And that's all I know about that.
Okay,
I'm sorry.
that's fine. Thanks.
At the time of this incident, she had a 14-year-old girl from down the street babysitting the kids. And this shooting occurred. The parties had a trial. She was found to be, I believe it's in page 9 of my brief. There were 3 standards under 19B3, B II, B3G, and B3K. And that is the parent had the opportunity to prevent the physical injury, that they failed to provide proper care and custody of the children, and that there's a reasonable likelihood that the child be, this will happen again if the child is returned.
Isn't the crux of your argument, counsel, that there was no determination at the the beginning of the hearing that whether there was aggravated circumstances?
I don't remember that was dealt with, no.
Okay. And do you see that as problematic?
I don't. I see this as an accident. I don't.
No,
see-
the trial court's failure
Oh.
to make findings on aggravated circumstances, which is needed in order to avoid,
Yes,
okay,
thank
all
you.
right.
But not every question from the bench is hostile. And you'll find we're fairly sympathetic to your position in this case.
Thank you.
I don't mean to speak for my colleagues, but I can't imagine what the aggravating circumstances were that would allow them to dispense with reasonable efforts. I just don't.
And so assuming that 2 out of the 3 of us, maybe all 3 of us feel that way, vacate, remand, allow the trial court to either make findings or take
Right.
another route.
Yes, I agree.
Any questions?
No.
Nick, do you have any questions? Anything else you want to
If I
indicate?
might, just one thing, the court
Okay.
held, and I think it's at page 131 of the trial transcript. The court said there's nothing in the record that guarantees that the mother would be stable and that a similar incident wouldn't happen again. Well, the standard isn't guarantees anything. The standard is reasonable efforts. And in fact, there was plenty of testimony. Mother seeing a psychiatrist, a psychologist, James Floyd, who's a visitation coordinator, Tammy Grozwalski, who is a foster care worker, Sarah Lawson, her paternity class supervisor, Dr. Shaw, who was her psychiatrist.
Counsel, she went out and she went out and affirmatively sought out services, even though they weren't provided.
Because they were not provided for.
Yeah, that's extraordinary. And I mean that in a very positive way.
Mhm.
Yeah.
And the fact that there was no compliance with the statute or with case law on making those findings of fact on aggravated circumstances.
Correct. Thank you.
I think we understand.
All right, appreciate it. Thank you very much.
Thank you very much, counsel. This matter will be submitted. Moving on to item number 14 on the docket. Oh, I missed 13. My bad. It's because it's after 14 in my stack for some reason. Item number 13 on the docket, People versus Christopher Lewis Greer, and this is docket number 368476. It looks like we have Mr. Wright endorsed. Good morning.
Good morning.
You can proceed.
May it please the court, Ally Wright from the State Appellate Defender Office on behalf of Mr. Greer. There's a reasonable probability that Mr. Greer was in a state of emotional excitement when he killed the decedents in this case. And the jury should have at least been permitted to consider that alternative.
But let me ask you this, because I'm just trying to figure out logistically how it would have made any difference. The jury was instructed on self-defense, correct?
Yes, Your Honor.
And they were given the option of murder 2,
Correct, Your Honor.
but they chose murder 1. And the way that you deal with lesser included offenses is you start with the greatest offense. You determine whether every element's been proven beyond a reasonable doubt. If that fails, then you go to the lesser included offense. Here it would have been murder 2. The fact that they chose murder 1 over murder 2, to me, defeats any prejudice argument that could possibly be made that there should have been an instruction on yet another lesser included offense. How would the jury have even had a discussion about manslaughter?
So I direct the court to Yeager. I really think the court's question right there is Yeager on all fours. In Yeager, same kind of situation. The jury was instructed on murder 1, on second-degree murder, and on self-defense. And that same argument that Your Honor just presented was presented there. And our Supreme Court still held that it was unreasonable and trial counsel was ineffective for not also pursuing an involuntary or a voluntary manslaughter instruction. And it really comes down to the difference in mens rea. So
Found prejudice.
yes,
Not
they
just
found
difference,
the
but also
court found prejudice. And it really comes down to the mental state or the mens rea.
It makes, I mean, and I'll go back and read Yeager again. Obviously, I read it in this, but that makes absolutely no sense analytically. I mean, nobody, I was a trial judge for a long time. You instruct the jury how to go through the verdict form. You go to murder 1 first. If you can't find that, then you go to murder 2. If you can't find that, then you go to voluntary manslaughter. I mean, I have lots of other problems with the fact that this just doesn't strike me as voluntary manslaughter even a little bit. 2 shots, 15-second delay, 1,000,000 shots. I mean, let's deal with that problem then.
No,
To
no
the facts, Your
knives,
Honor.
no knives,
Right.
other than
The ones in the
one in the
backpack.
backpack. He claimed that he was threatened with by one of the victims holding a knife. There was no evidence that would corroborate that position. So I think it's kind of a combination of things, as Judge Yates indicates, as well as, looking at the evidence objectively. They didn't buy the argument that this was self-defense or the heat of passion or anything.
Well, to be clear, Your Honor, the jury was never told about heat of passion. So just to be clear, we're not considering that because they were never told about that.
Okay.
With respect to, Yeager is on this on all fours, and I understand.
But not factually.
So let's talk about
two
the facts.
shots, 15-second delay, then he just opens fire.
So let's talk about the facts. Because obviously I don't think this court can reverse Yeager. let's talk about the facts though, and
No,
whether, and whether
I-
Jaeger.
Right, I'm not
whether
saying
this-
we're gonna disregard Jaeger, but I mean, my gosh, this case doesn't strike me as voluntary
Sure.
manslaughter even a little bit.
So, and I think the facts are important here. One, in terms of, let's not even worry about the knives just yet. The audio recording. The audio recording of the shooting, I think, is very powerful and it's shocking to listen to. Mr. Greer, this is an argument about infidelity. Mr. Greer is yelling at the top of his lungs on repeat, like a broken record. Leading up to the shooting, he's yelling, "That's what you did. That's what you did. That's what you did." Seconds before the shooting, he's yelling, "You did it. You did it. You did it." As he is shooting, he's yelling, "You said you did it. You said you did it. Say it again. Say it again." And then after the shooting, he's yelling, "What the F are you talking about?" And we're over and over and over. He's shouting this over and over again. And he's exclaiming like that repeatedly, talking to himself at the top of his lungs. This is wholly consistent with the behavior of a man who's completely excited, who's out of control, and who's enraged. And the second thing I'd like to point to, or the second fact I'd like to point to, we also have Mr. Greer's trial testimony where he says he shot, and this is his own quote, "in the heat of the moment." Those are his words. His attorney wasn't pursuing this. Those are his words describing this. He's not an attorney, and he used those words. He doesn't even know the legal significance of those words, and he used them.
Let's assume that we agree with every single thing you say. How is it not first-degree murder to shoot Cheyenne Hall?
And that's the
I mean, he can't just kill everybody in the room because he's mad at one person. That's crazy.
So I don't dispute that that is a more difficult or more problematic part of the argument, but that's also addressed in Mr. Greer's briefing, and I guess it's kind of 2 points there. One, people do irrational, crazy things when they're in a heat of passion, when they're in an completely excited, emotional state. So that's first. And then second, even if the court were not to reach that conclusion with respect to Ms. Hall, Mr. Greer's case can have a long life beyond this court through habeas, et cetera. We need to get, or this court, our courts need to get our verdicts, our sentences correct. And to the extent Mr. Greer is serving 2 life sentences, and if he should be serving one, if he should be serving one, then at least we should get that right. Or at least the jury should consider that and not have him be serving 2.
Right, because as I was sitting trying to parse this out, it just struck me that there is no possible argument that reduces the murder one charge against Cheyenne Hall.
I will say it's a difficult argument. I would not say there's no possible argument. I think I stated my argument in terms of what people do when they are in an emotional state like that. But again, to the extent I've convinced the court, at least with respect to with his girlfriend, then there should be a reversal here, at least with respect to her.
Counsel, I mean,
Yes.
you obviously, you need more than heat of passion, right?
Correct.
You need that adequate provocation.
Correct.
So, I mean, you can obviously be as upset as you want to be, but that doesn't make it voluntary manslaughter. So what rational view of the evidence supports adequate provocation?
Thank you, Your Honor. A few things. So one is, it's almost, I don't want to say it's a textbook law school argument about, finding your spouse cheating on you or something. But this is an argument about infidelity at the end of the day. Things do start to go off the rails. And then secondly, this is based on Mr. Greer's testimony, and his testimony is evidence. There are knives found out in the apartment. So I'm not sure, and maybe I need to read the record more closely. I'm not sure. I thought that an officer testified that they found knives out. Now, I know one of the sisters came over and said that was her knife. So there's a factual dispute about whose knives they were and where they were.
But that would be for the jury to resolve, not for us on appeal.
Correct. So all this, I guess my point is all this, there's knives involved. There's Mr. Greer testifies that he was cornered during this argument, this very heated argument about infidelity, and that this kind of all reached a boiling point. And that really, I really think that comes through in the video or the audio recording of this offense, because you can hear him. I mean,
Yes.
it's
Yeah,
It's
he's very
it's
upset.
very shocking to listen to. And I think that really supports the possibility that a reasonable jury could conclude that when they're hearing someone talking like that, yelling at themselves like that, even after he shot these people, that that person is in a complete state of emotional excitement. That's not something that calm people do. And I think that's really telling or compelling in terms of the facts of this case. At the end of the day, this is an ineffective assistance of counsel claim, and this court must determine whether trial counsel performed efficiently by not asking for a voluntary manslaughter instruction consistent with Yeager. And everything indicates yes to that question. Now, and we already discussed about that tension between self-defense and voluntary manslaughter, and Yeager kind of squarely addresses that. I know that was raised in the prosecution's brief. I believe Judge Yates asked a question about that, but I'd also point to it's not only supported by the record of facts of the case, but by the offer of proof that was submitted in support of Mr. Greer's motion to remand. And even trial counsel himself agreed that voluntary manslaughter would have been an appropriate either primary or secondary defense. And that he believes, this is trial counsel saying this, that he believes he should have pursued it. So it's omission by his own admission. Its omission by his own admission was not strategic because he acknowledged that he never considered the possibility of a voluntary manslaughter instruction.
I'm also going to go back and take a look at Yeager. I've pulled it up, but I want to hear your argument. But I want to understand, is it your position that anytime that Yeager mandates anytime there's a charge of murder that this instruction must be given?
No, Your Honor. I think that would be overly broad of a reading.
Okay.
The question the court must ask itself is whether there's some level of facts to support this a reading or to support voluntary manslaughter. Now, it's not this court's job to be like, well, if I was on the jury, I would have decided against. The question is there enough enough of a factual basis here for there to be some kind of reasonable dispute or some kind of reasonable support for it? And that's the case here. Yes.
I apologize.
No. Yes, Your Honor.
So just, I want you to, I guess, walk me through sort of how you think about prejudice here then. So let's say I agree with you. Counsel was deficient because at least by defendant's testimony, there was, some basis to ask for the instruction. We move to the prejudice prong. And let's say I agree with you there too. Let's say, the fact that the jury chose the path it did doesn't tell us about what path it would have chosen if it had been given the proper options. When I look at the evidence and its strength of support for voluntary manslaughter, I know, when we're talking under, the Cornell test, you look at substantial evidence. Is that what I'm looking at here as well? How do I think about prejudice here? Do I say, okay, well, the instruction should have been given because there's a rational view. Do I then look at whether there was substantial evidence in support of it for the prejudice, or do I look at something else?
So, and I'd refer, and if I would refer the court to the prejudice section of Yeager. I believe it gets into this, but I do recall the Cornell test. I think that's one thing the court could look at, but it's really, again, I think I kind of touched on this a little bit. At the end of the day, for an ineffective assistance of counsel claim, the ultimate question is reasonable probability of a different outcome, right? And the different outcome here is, should this instruction have been given? The different outcome is it possible that is it possible that a reasonable jury could have reached this conclusion? So I think that I keep coming back to the word reasonableness. And I think that's what this court's inquiry or analysis should really look at. Not necessarily reasonableness in terms of, again, what I have personally, if I were sitting on this jury, reached this conclusion, but reasonableness in terms of, is there a reasonable support for the elements of manslaughter here? And we do, the record does show that we do have reasonable support for establishing such.
And is that, I guess, is that just based on your client's testimony?
No, well, it's based on my,
I understand you have the audio recording that shows heat of passion.
Correct.
Or yeah, that's your argument.
correct.
And then I guess for the adequate provocation prong, that needs to be there. You say you have your client's testimony about knives. What else is there?
We have my client's testimony about knives, and most importantly, we have.
Your client's testimony about knives goes to self-defense, not voluntary manslaughter.
I think
He says they covered the exits, they had knives out, and I had to do something. That's self-defense. That's not, he's thinking through what he's going to do about these two women armed with knives. It's not voluntary manslaughter, that's self-defense.
I'd respectfully push back, Your Honor. I think it can be both. In that when knives are introduced to an already volatile situation, someone might think self-defense, I need to protect myself. That's one, but also someone still thinking I need to.
That's not heat of passion. That's thinking rationally. That's not thinking irrationally.
But also someone in that situation can think we're having this argument about infidelity. I'm already seeing red, and literally, as you can hear from the audio recording, kind of loses their mind. And so I don't think, with respect back to Judge Mariani's question, I think it's both the knives and it's both this argument about infidelity. It's both. I'd say those are the core facts in terms of Mr. Greer's testimony that kind of work here together to create a situation where a jury could find heat of passion or excitement.
And please deal with what I believe is the strongest argument against manslaughter. 2 shots, 15-second silence, then he just unloads. I listened to that. That is a lot of shots being fired after he thought about it.
I listened to that too. And so I think this is actually laid out in my brief, but I think it's the court can obviously listen to the recording again. If I'm recalling correctly, it's 1 shot, and then there's about, I think I looked at the timer. I think it's like 10 seconds, and then there's a bunch more shots. And I think to answer your question, Judge Yates, what kind of, because what you're really getting at is, was there sufficient time to calm down, to think?
He was faced with the fact that he had just shot somebody. And instead of thinking, oh my gosh, what have I done? And stopping, he stops, he waits, and then one of them got hit 8 times, another one got hit 6 times.
And that precisely supports Mr. Greer's point, or appellant's point here, which is when you listen to the recording, that 10-second delay between shot and then a bunch more shots, he's still yelling at the top of his lungs. He's still completely out of control at that point. I think the court's argument would be, or maybe even the prosecution's argument would be persuasive to the extent there was silence, time to reflect. But that's not what's happening. You can hear from the audio, he's still losing his mind. He's still talking, screaming at the top of his lungs, saying these repetitive phrases over and over and over. He has not calmed down. He has not calmed down at all. So yes, you could have a situation where someone shoots someone, it's like, oh my gosh, and it kind of snaps them out of it, what I had done, and they calmly, and then but there's no silence there. He is almost, the audio recording is almost a stream of conscious into Mr. Greer's mind, let's say at that point, and he just keeps going with these repetitive phrases, and even maybe I'm being repetitive now at this point, but I think him saying those things over and over and over again before more shots occur, I think that really shows that he did not have, that there was no calming down whatsoever. And him continuing that even afterwards shows he's still excited and not calmed down well after the shooting. And so I'd point to that. I'd also point, and I'm blanking on the opinion. I'm trying to remember if it's not. 1 second, Your Honor. I have it up here. It's Hofmeister. Yeah. I guess I'd also refer this court to the Supreme Court's opinion in Hofmeister on that point, just in terms of, I'd say the number of shots here, because it is a shocking number of shots.
It really is.
It supports a possibility of manslaughter. People don't shoot their girlfriend 8 times.
And their girlfriend's sister.
8 times
And he would
calmly.
have shot anybody else in the room, for goodness
They
sake.
don't do that calmly, Your Honor. They do that when they are completely in this excited state and they have no control. Just to, I guess, close out, I'll rest on the briefing with respect to the felon in possession claim, but Mr. Greer respectfully asks this court to vacate and his convictions, remand for a new trial, or in the alternative, to the extent this court feels that further evidentiary development is needed because the trial court, there's no Ginther here, that this court remand for a Ginther hearing.
Thank you.
Thank you
Any
very
additional
much. Thank you very
questions?
much.
All right, thank you very much, counsel. This matter is submitted. Moving on to number 14 on the docket. And this is docket number 370342, People versus William Mann. And counsel, ready to proceed.
Yes, good morning, Your Honors. May it please the court, Ian Kerpaw, P72110, I'm Mr. Mann. Hope Your Honors are doing good this morning. So what we have here is, as in most cases, CSC cases, a pure credibility contest, right? We don't have DNA, we don't have witnesses, we don't even really have prior acts or 404B stuff that came into this. You know, the prosecution basically presented the complaining witness, and I think the officer who took the report, but that's pretty much the prosecutor's case in chief. And when we're looking at a case such as this, the credibility of the complaining witness, the Mr. Mann, certainly come into play here. And a jury has to determine, well, Mr. Mann never testified, but a jury has to determine.
Right. It's not really a credibility
Right, yeah,
contest. He didn't take the stand.
Right, which, fair enough. But we got to determine, okay, is complaining witness credible, right, with her allegations here and her testimony. And I think trial counsel missed some opportunities here to effectively impeach her credibility here. She did testify at the preliminary examination. There were things there that were said. She had been testified to a trial. She left out certain sexual acts, and she left out stuff about the hot tub.
Right. But it's not the case that defense counsel didn't cross-examine her. You just don't think he cross-examined her enough, right? But isn't that a classic strategy decision? I mean, you don't have to cross-examine a witness for 2.5 days to satisfy your obligation to provide effective assistance of counsel.
It is strategic, I would say, but it's got to be reasonable, right? I mean, we can't leave out effective impeachment. We can't leave out cross-examination effectively impeach the witness, right? There's Trachtenberg and all that other stuff.
Right, but defense counsel did cross-examine her, did point out inconsistencies. I think your theory is he just didn't do it enough.
So my theory is he didn't do it effectively because he had really great opportunities here to impeach her with preliminary exam transcripts, text messages, and all that stuff. Because what he missed from the preliminary examination was there were some allegations involving the bathtub and the master bedroom. And certainly at the prelim, she said, hey, the master bedroom had the sink, vanity, shower. And there was some issue, of course, at trial. Was there an actual bathtub in the master bedroom? She testified there was some acts that occurred in the bathtub in the master bedroom. And certainly we could have got back to, well, at the preliminary exam, did she testify? There was just the shower there. There was no.
Right, but he called 2 members of the family to say there wasn't a bathtub. I mean, if he thinks he has her dead to rights on that, if I'm a defense attorney, and I was a defense attorney for a long time, if he thinks he has her dead to rights with 2 witnesses sitting behind her from her own family, he's going to, why does he need to pound away at her on that? Let her stand by the statement she made. Put on her brother and her mother. Let them directly contradict her and then tear her up in closing argument. What's the point with arguing with her about that?
Because William indicated some memory issues. He didn't exactly remember, right? And there was some issue even with Miss Pack saying, well, there was some renovations done in that regards. But here you have it out of her own mouth. I think that's a lot more powerful than getting it from the mother or the brother when the prosecutor's own witness is saying, well, yeah, there's just a shower in there. There was no bathtub in there. It's incredibly and then allegation. And we also look at the preliminary examination. She didn't say any allegations about the hot tub. And for good reason, because she's at the preliminary examination said, well, this happened summer 2008. And of course, the hot tub was never fixed until 2013. So she couldn't say anything happened in the hot tub in 2008 because there was no hot tub in 2008. It wasn't even fixed. But I think there's just issues there. And I know the prosecutor in their brief was saying, well, we don't have to show everything, with prove everything at the preliminary examination.
Right. I mean,
It was going to put on some evidence.
Right.
But my
You don't want to require a prelim to look like a trial.
But my retort to that is they couldn't ask her about the hot tub allegations because she claimed this happened in 2008. So they couldn't ask her about things that happened in 2013 or because the hot tub was fixed in 2013.
Well, I mean, there's no doubt that everybody was a little confused on dates. I mean, her mother had to have her recollection refreshed about when they moved into the house. She was off by 2 years. I mean, the problem is we're looking back almost a decade.
Right. Right. And I get that. And that's why I think because we're looking back a decade and how the important the credibility is here, we really need to hammer and focus on the credibility issue and use everything that trial counsel has in their quiver, I guess, to really go after the complaining witness here. I mean, because that was basically his case, right? It was, we're just going to cross-examine her, bring in witnesses and attack her credibility that way because he didn't have Mr. Mann testify. So you have to use these tools you have. And one of these tools he had was the preliminary examination transcripts. And I know the date things are confusing, but again, the preliminary examination, she's talking about, well, this happened in 2008 when she would have been 6 or 7. And of course, at trial, we're talking about, well, the abuse started when I was 10, 11, or 12. So now we got this range that abuse could start from 6, 7, 8, 9, 10, 11, 12. I know the prosecutor and even at the motion hearing, well, we don't have to prove time or specific date. But certainly it comes out to credibility, right? I mean, if the jury hears, well, the abuse could have started at 6 or maybe 7 or maybe 8 or maybe 9 or maybe 10 or maybe 11 or maybe 12. I mean, as a jury, you're probably sitting there going, well, come on, because the complaining witness, when she testified, was an adult. I mean, I get it if she was testifying, she was still 12, like, oh, okay, she's 12, right? But she was adult when she testified. So if the jury sits back and gets to hear all this, well, wait a minute, now she's claiming it happened at 6, 7, 8, 9, 10, 12. And this goes back to when she claims it ended too, right? Because she was kind of wishy-washy on when.
Well, she
the
does
abuse ended.
she does tie that up to when she started to get her period and when her grandmother moved in. She may not be able to know exactly the month and the year, but she knew that those two events occurred, and the period matters a great deal because that's when he said, "Oh, that's gross. I don't want to do that." I mean, it seems to me that is tied down about as tightly as anything can be.
And so, and I would agree, she kind of focuses on 13 as being, or when it stopped before she turned 13. She was 2001, so she would have turned 13, I guess, in 2014. But she also said, well, the abuse stopped before my grandmother even moved in. And grandmother moved in 2013. Again, I wish we had an exact date, but we don't.
Right.
So that meant the abuse could have stopped when she was 11 or 12, depending on when the grandmother moved in. So then we have the situation of, well, the abuse might have started when I was 12, but might have ended when I was 11. So again, that's why I think you got to bring this exam transcript on, well, didn't you say before it started in 2008? You could have been as long as 6. And you're saying it could start when you're oldest 12. I think that goes directly to her credibility. And this isn't her having to do math quickly in her head, as sort of the trial court indicated in her order. Big difference between 6 and 12. I mean, we're not talking 1 or 2 years apart here.
I don't understand that comment. You don't have to do math in your head. Can you, what do you mean by that? It's not that this individual who claims to be repetitively assaulted by her dad, now she's an adult, so she should remember everything perfectly? I'm trying to understand what you mean by that.
Okay. Well, the trial court had in their ruling had made some motion indication like, well, the date thing is really just goes there she can do math quickly in her head. And it's not like we're asking her to, okay, subtract this date from this date and figure it out. I think there's a huge difference between saying something happened when I was 6 and 12. I mean, I'm not parsing 11 or 12. I wouldn't be making, if she was going, well, it happened when I was 11 or 12, I wouldn't be making that argument because sure, it's a long time. But I think even over time, you can differentiate between something that started when you're potentially 6.
But I thought she was really clear that the vibrator was before they moved into the house. Then they moved into the house, and we know when they moved into the house, and that's when the actual contact-based sexual assault started.
Correct. And then they moved the house in 2011. At the prelim, she said this abuse happened in 2008 before they moved the house. Right. And of course, the vibrator thing, which was before, she also testified that no abuse happened before they moved to the Great House Road either. So the vibrator thing, I don't know, maybe in her mind, it doesn't equal abuse. I don't know. But I think just, we have stuff during the preliminary examination that really could have been used. And then we get to, text messages, because complaining witness talked about, I resent my dad, I'm in fear of him, I stopped talking to him, and basically made the impression she hates this guy because of what he did to her. But then we have these text messages where
Right.
we're still talking.
the
I
jury
love you,
says-
I miss you, happy Father's
The jury
Day.
knew about those.
The jury didn't know about the text messages. They
No,
were,
the jury knew that her dad had gone over to her house.
I believe she testified the one time, but what they didn't know
Yeah, right,
is,
right. After she moved into her house, she got married, she moved into her house, and he went over. And she had originally said at the prelim or somewhere that she hadn't spoken. So she was impeached on that.
not effectively though, because if she's texting him, I love you, when she's just testified to, I hate this guy, I resent him, I fear him, I don't want to talk to him anymore. If she's talking about, hey, come over with soup, hey, aren't you coming over? I mean, one time is a lot different than repeated requests to, hey, are you coming over? Hey, I miss you, I love you. Can you bring me soup? I mean, this idea that because of this abuse he did to her, if you believe her, caused her to have this resentment towards him, this fear towards him, that she didn't want to talk to him anymore when she moved out of the house. That goes directly to her credibility and impeaches her there. So that's why I think it's important to get those text messages in. And then we move on to Ms. Pack's testimony. Her mom, yes, her mom. It sounds like the plan there was Ms. Pack was going to actually testify to a specific date the hot tub was fixed. And then to, the sort of notice to quit when she was going to have to move out. And of course, at trial, right, I don't know what happened at trial. Trial counsel obviously has this theory. And then, I had affidavits from my investigator talked to Ms. Pack and says, well, no, I never even talked to him till the day before. But it looks like the day of the hot tub certainly was important. It was fixed because her allegations occur in the hot tub. So if she's claiming things happened in the hot tub when it was broken, that certainly attacks her credibility there. So I can understand why you'd want Ms. Pack, the mom, to say specifically when
Right.
things were done.
Right.
And if trial counsel's thing was, hey, we talked about this, she was going to agree to testify this, and so she shows up and I have memory problems or whatever happened. He probably should have impeached her at that point. Then we talk about this. And I know the issues are obviously he can't be his own witness,
Should have been, right, he should have impeached his own witness.
which you can do. Sure.
No, I understand
Yeah.
that, but I mean, she gave him a lot of valuable testimony, like there was no bathtub.
Mhm.
I mean, why in the world? And there's a lot of animosity between the mom and the daughter too. Why in the world he would have called her as a witness and then impeached her that totally escapes me. I mean, how you could say that is not a strategic decision that's insulated from review.
Because if one of the allegations concerns the hot tub, you have to somehow deal with that allegation of the hot tub. And if you're saying Ms. Pack was going to testify to these issues with the hot
If
tub,
she gives him
Winnow.
80% of what he wants, but she won't give him the last 20%, he's then required to bore in and try to undercut the credibility of the witness he called who gave him 80% of what he wanted.
I don't know how it undercuts in that regards. I mean,
You just said he's going to attack her credibility by impeaching her. I've tried a lot of cases as a defense lawyer. The argument you're making here makes absolutely no sense to me.
I mean, trial practice to some extent is theater. And there's a jury sitting over here. And how that jury perceives each of the lawyers in their treatment of witnesses is also pretty important. It's not addressing elements. It's you want them to think you're not the bad person, that you're going to treat these witnesses a certain way, and the jury will, again, by pulling together testimony of various individuals. I mean, I'm with Judge Yates, though I have not defended. I've not served as a criminal defense attorney, but I was I was a prosecutor, and I mean, that's kind of like the soft skill. And I'm having difficulty because I'm thinking about that soft skill And that's all strategy.
And I do trial work too. I've done trials, so I understand where you're coming from, Your Honor. And this idea that, well, we can't attack her credibility, but he kind of did though, right? Because he brought up the piece of paper and was showing it to her.
That's
And
refreshing
kept
recollection.
asking her repeatedly, doesn't this refresh your memory? She kept saying, no, 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 no.
Right, that's refreshing recollection because what you're trying to do is get positive testimony by
Mhm.
jogging her memory and getting her to testify.
But the jury's seeing that too, and the jury's seeing her, whatever reason she had for not remembering, not refreshing her memory, but he's still badgering her with it though. So, I mean, it's not like she says, I don't remember. I said, oh, okay, I'm gonna back off now. I mean, they kept going at it. So, I don't think it's necessary.
I wonder, I think we might be just unable to, reach it doesn't sound like we're going to necessarily say, yes, that's a winning argument here. And I
And
think
I'll
we've
move on.
yeah, that's what I'm getting at. Can we
I'm
talk
reading the
about
room.
this?
I'm moving on.
You know, if you want to talk about your second issue, you might find a lot of support for that.
Yeah, the
argument.
CSC too.
Okay.
Talk about that.
I think you're right on this one.
And well, thank you. I think I would too. So,
Again, I can't speak for my colleagues, but it sure seems like
right.
a winning argument.
And obviously we charged the CSC 1 and the CSC 2nd, and the CSC 2nd had regarding sexual contact that occurred. And even the prosecutor talked about, well, I could have charged this multiple times, and there was even a theory like there's actually 3 separate and distinct acts. And I think
Sure, and they could have charged him, but they didn't. That's the
Right.
point.
yes.
Instead, they left it open,
Yes.
so any one of the 3 could have worked. And I mean, that is a class problem.
Correct. And I think this fairly squares with Yager. I read the case last night, and I still don't see how it's any different. But yeah, I think that that's an issue there, and I think defense counsel is ineffective for.
Well, talk to us for just a moment about this, because I don't think there's any question, even the trial court found in the post-trial motion that there should have been a request for a specific unanimity instruction. So even the trial court agrees with, I think, where we're going to land on that one. But the trial court deals with it as a matter of lack of prejudice. You want to talk about that? Because it sure seems to me like it was prejudicial, but why don't you go ahead and make your pitch on it?
I would agree it's prejudicial too, because again, I looked at the Yager case again last night. And I'm like, how could this argument be that's not prejudicial? I was trying to get something from Yager to sort of counter that, but sort of Yager in this case seemed to go together quite well. So I think there's just too much of a danger there that 6 jurors thought one thing, 6 jurors thought the other thing. We're gonna have a unanimous verdict here. I mean, I get it. I mean, if the prosecutor's argument, I think, is like, well, there's just so much evidence here. Of course they would have came to this. But then I go back to Yager and I'm like, well, Yager is kind of the same thing. So I don't, really know how to parse that there. So I would just rely on Yager and that argument, Your Honor.
Thank you very much, counsel. Any additional questions?
No, thank you.
Terrific.
Okay.
Thank you.
I did have other issues, but the rest of my brief looks like y'all are done with me. So.
But I think since you're unopposed, you only have 15 minutes, and I think.
I think we've exhausted.
Oh, I'm sorry.
More than exhausted
Yeah.
15 minutes.
All right.
I mean, not that we haven't enjoyed this, but.
And Judge Yates, congrats and
Thank you.
Best wishes on your new endeavors. Yeah.
Thank you very much, counsel. This matter is submitted. And we are next moving on to number 15, and these are consolidated cases on our docket. People versus Brent and Thornton, docket numbers 370241, 370474. Good morning, counsel.
Good morning, judges. My name is Robert Tomac. I represent the appellant Brenton Michael Thornton. Judges, I don't have any thing of substance to add to my brief. I would say, I do want to say, though, I concede with, agree with the prosecution regarding the standard of review on the second issue having to do with the out of court statement by the defendant. And that should have been abuse of discretion. Our argument still stands, though, that statement was practically an admission of guilt. I know that I presume it had a certain amount of weight with the jury, and So that would be the extent of our, otherwise I would just rely on my brief.
Thank you, counsel.
Good morning. May it please the court, Deborah Blair on behalf of the people, the Wayne County Prosecutor's Office, the appellee in this matter. The defendant has raised two issues in his brief on appeal. I think the briefs thoroughly cover both issues. Therefore, I will stand on my brief unless there's any questions.
I have one or two. I mean, you also have a standard 4 in this case, I believe.
Yes.
Number of issues. And are you prepared to speak to those at all?
The one issue that I was prepared to speak to was the lifetime electronic monitoring issue. And when I looked at the statute and the correction was made within 6 months. So I think the amended statute allows that because lifetime electronic monitoring is required by the state law. So it was invalid not to have put it on there.
And you're given an opportunity to be heard, so under the current.
Under the revised court rule.
Right, the one that I think. Do you have any position on the Fourth Amendment violation?
Refresh my memory.
Very, very broad warrant. Seems pretty tough to square with People v. Carson.
Right, there's a new Supreme Court decision that I think Judge Mariani correctly indicates is a huge problem.
On the cell phone?
Yes.
Oh,
The images are
yes.
retrieved to the cell phone.
That could be an issue, although it wasn't raised.
Within the standard 4.
Yes. But it wasn't raised in the trial court. But
In fairness,
And you-
I don't know how it could have been, though. The Supreme
Well,
Court
right, yeah, I
decision
mean, we
came
don't-
down in
You could have made the argument, but we don't.
Right.
But understood.
Right.
Nonetheless, the issue is still presented in whatever form of
Right.
preservation posture it is. We still have to deal with it. So we have, a warrant that, seems defective under currently binding precedent. And I mean, I guess if you don't have if you don't have an argument on it today, that's fine, but I wanted to give you the opportunity to address it.
well, then you'd also have to look at the substantive evidence that came out of that warrant that was admitted at trial. And most of the substantive evidence, the birth certificate, the vibrator, those things had no relationship to the search warrant. So I
Well, the
think
photographs, I think, right? Or their images
there were
on the
photos.
phone
Yes.
that presumably if you rule that, if the ruling is, the warrant was in violation of the Fourth Amendment, and if the consequence of that is that the images. Yeah.
Yeah, but the images weren't such that they would overwhelm or discount the testimony and the other evidence in the case. They were, if you look at the pictures, that they don't prove the case. They're proof that they were together, but they don't prove the sexual acts that occurred. In this case, 3 counts of CSC1, 2 counts of CSC2, and 1 count of CSC3. So I think you could remove those pictures and still preserve the conviction. Okay, thank
Any other
you.
questions?
No.
Good. Thank you very much, counsel. Brief rebuttal if you need it. Thank you. We're going to move right along then. This matter will be submitted. And we are up to item 17 because 16 was earlier. Good morning.
Morning, Your Honors.
Let me put the case on the record and then we'll hear your appearance. And this is docket number 369611, Doan Restoration of Michigan versus Christine Rowe. Proceed, counsel.
Thank you, Your Honors.
Good.
I was told that
sorry, Your Honor.
not appearing. I don't know if that's still true.
Ah, Oh,
Let's see.
let's take a look.
Better to find out.
Your Honor, I'm here. Hopefully you guys can hear me okay.
Excellent. And you are Mr. Noel?
Yes, Your Honor.
All right. And he is endorsed for oral argument, counsel, so we will give him the floor. And you can proceed when ready, counsel.
Okay. I will be relatively brief and kind of open it up to the questions I imagine you all have. Again, my name is Richard Noel. I represent the plaintiff appellant, Doan Restoration of Michigan. This appeal is from an order granting summary disposition and basically dismissed Doan's defamation and tortious interference claims. The crux of the evidence that was at issue is a recorded phone call purported to be with a homeowner and Wesley Doan of Doan Restoration. And the nature of that call is essentially when Doan asked, "Hey, why are you not going with us?" Somebody to that effect. The homeowner said, "Well, my insurance agent, in this case, we're alleged defendant Roe, basically."
Let me just stop you there because as I recall there, we don't have the recorded phone call.
That is correct, Your Honor. All we have, unfortunately, is the transcript of the recorded phone call. That is actually, I believe it's in the motion. It was played at the deposition of the homeowner, Matt Janilla. So unfortunately, that is all we have, but it does have the substance of it.
And the homeowner is a non-party who told her.
Yes. Well, I mean, I think that's the question. I mean, our position is essentially that the conversation appears to have taken place prior to litigation, very early on, when he was still deciding who to go with to make the repairs to his home, and that was close enough in time that it's reliable. So I think the question of whether or not he told a lie, whether he was lying then or whether he's, oh, I'm sorry.
I'm sorry to inject, but could you please explain what you mean by it was made close in time, therefore it's reliable? Is there authority for that?
Apologies, Your Honor. I mean, I kind of gotten off track. Essentially, the points that we've raised are that the recorded call is not hearsay and should have been admissible. Unfortunately, because that was deemed inadmissible hearsay, the case essentially was dismissed.
Wait, hold on just a second. So you say it's not hearsay because it's a verbal act or for some other?
Yes.
Because I'm not sure whether you're relying on one or several exceptions to the hearsay rule. You're arguing that it's not hearsay or something else, because if you're arguing it's a verbal act, I do not get that argument at all. I can see some of the exceptions you've relied on, but to call this a verbal act seems to completely mischaracterize it or to fundamentally misunderstand what a verbal act is.
And that's a fair point, Your Honor. I mean, ultimately, our position was that it is a verbal act and that it's essentially the act of the act is the effect that the alleged statement, the inside statement, I'll call it, the statement that's alleged to be made between Janilla and Roe, that the act is the effect that statement had on Mr. Janilla, which is the outside statement between Janilla and Doan. It gets a little confusing because it is a statement, essentially a statement within a statement.
Right. You have two layers, and so you have to justify some way getting around the hearsay problem with each one of those two layers, right?
Yes, and I think the inside layer, most importantly, is overall, I don't think it matters whether or not the statement, the inside statement between Janilla and Roe, assuming that took place, doesn't necessarily even need to be true. And it doesn't need to be offered for truth. It simply just needs to be offered to show that it had the effect of Mr. Janilla saying, I can't go with you guys because if I do, I won't have coverage with my insurance. So I think that inside statement is just not hearsay at all. That's Doan's argument.
Back up to the first problem, not that one. The first problem, that's where I don't understand how you could possibly invoke the verbal act argument.
Okay, fair enough. Give me a second here. Give me a second. Sorry, apologies. Let me just pull up what I've got. I've got notes here. Sorry, technical difficulties. This is my first virtual appearance here at a Court of Appeals argument. So let's see.
Right. It's the statement from Roe to Janilla.
Yes, and again, our position is that the verbal act is the act again that it's how. Hopefully, I can frame this correctly. That makes it understand how Janella interpreted that inside conversation, whether true or not, and the effect that that had on Janilla. So that's our main crux is that it's not hearsay because it is a verbal act. However, even if the court is willing to ignore that argument and say, hey, it misinterprets, I think that we have enough exceptions alternatively that it should have survived.
For Roe to Janilla, what would those exceptions be?
No, from Janilla to Doan.
Right. I'm not talking about that. I'm talking about Roe to Janilla.
Okay. Again, I think that in order for it to be hearsay, it would have to be offered for the truth of the matter asserted. The truth that is alleged to be asserted is we don't hire Doan, we don't use them, and we won't cover you if you do. So that's the inside statement, right? That's the Janilla to Roe statement or Roe to Janilla statement. Now, the argument is that it doesn't matter whether or not that's true. It's not being offered for the truth. It's just simply being offered to show that this statement had an effect on Janilla, on the outside statement. So again, it is the main argument is that it's not hearsay because it doesn't matter if the statement's true. And in fact, we know from affidavits that were produced later that the statement itself actually was false. They do work with Doan, so it was a false statement. Granted, that came out later in depositions, but again, for the purposes of this argument, that inside statement again wouldn't be subject to hearsay because it's not hearsay.
I'm glad that you have acknowledged that, in fact, the defendants do work with your client, and that causes me to question what are the damages?
Well, I mean,
how is there any harm in a non-party lying? Where is the harm?
I think the nature or the events that are talked about in the statement between Janilla and Doan, the overall statement where he said, I would have gone with you guys because my neighbor recommended you, but for the fact that Roe made this statement to me, I'm not using you. That right there is very clear. Our arguments is very clear harm to show that, hey, you could have gotten the job, but I couldn't go with you because my insurance is, the coverage would change based on you guys being the ones to do the work. So that's the harm.
So the harm is that the homeowner who didn't like the crew sent to the house and didn't use them, that's the entire basis of the harm underlying the claims you have asserted.
Well, I mean, I know there was an expert opinion at the trial court level. We did not include it in there, but I know it was discussed regarding the expert and how that harms reputation in the community because it is a tight-knit community. And now clearly we have at least one person saying, hey, these guys are good, and another person saying, oh yeah, you can't use those guys. And they obviously speak based on, again, the contents of the conversation itself. And I think furthermore, the point of that he didn't like the crew or anything like that, I don't think that the evidence shows that at all. I think it shows that he would very much would have gone with Doan, but for the statement.
Okay. Any question?
No, not for me.
Okay. You can either continue or we'll save a few minutes for rebuttal, counsel.
I'll save a few minutes. Thank you.
All right, thank you.
Thank you, Your Honors. I think the statements on the recording are quintessential hearsay. They don't fall within any exception. Definitely not the catch-all exception. And because when you look at whether these statements are reliable, you have to look at the evidence here. We have Christine Rowe saying she never made those statements. We have Matt Janilla saying Christine Rowe never made those statements. And we have Matt Janilla saying, you know, if I don't recall saying that on the phone call, but if I did, you know, I'm non-confrontational. I didn't want to have a dispute. And that's not unreasonable. I mean, I think every one of us does that when we want to get off the phone with someone who's, for one, you know, a contractor doesn't just call you to put you on the spot about why you're not hiring them. That's kind of odd, but so I think his explanation is perfect. So the only way either of these claims go anywhere is if that recording is admissible, and it's not. So I think that defeats the whole case. But, you know, when we talk about the truth of the matter asserted, the truth of the matter asserted really is that she made these statements. It's not that, you know, how he framed it as whether they actually used DONE. No, the truth of the matter asserted, the issue is, did she make the statements, not whether the statements are false. So I think that's where he kind of gets off on the hearsay analysis a little bit. But, you know, one thing I will say is that even if these statements are admissible, they just don't establish defamation. They don't establish tortious interference. They aren't capable of defamatory meaning. They don't tend to lower the estimation of DONE in the community. And, you know, you asked, Your Honor, about the harm. This statement never, if it was made to DONE, it never went anywhere else. And we have Matt Janilla saying he didn't hire DONE because he thought the crew was unprofessional. There's nothing disputing that. You know, it's, I don't have much more to say. And the legitimate business expectancy on the tortious interference. I mean, this was wishful thinking. They keep talking about this recommendation. All Matt Janilla said was, I called DONE because I knew DONE existed. My neighbor used it for something. Oh, did your neighbor recommend him? No, I don't remember that. Did your neighbor praise him? No, I don't remember that. It's just literally he called DONE because DONE existed. So, I mean, there's no legitimate business expectancy in that type of arrangement. But if your honors have any questions, I can rest on my brief for the rest.
No questions.
Thank you, your honors.
Thank you. Mr. Noel, rebuttal.
Yes, just very quickly. You know, we did cite, you know, 8031, 8035, and 80324 now defunct. You know, it's our position that they apply for various reasons, be it, you know, the fact that well, let me back up. To the point that the statements have absolutely no reasonable way of causing any kind of defamation or defamatory meaning. Obviously, we've mentioned it in our brief that there's a very clear insinuation of we can't, if you use this company, you are not covered. That's a very clearly an insinuation of there's some sort of either substandard or something about DONE that is not acceptable for them to warrant coverage. That absolutely, I think, has an insinuation of defamation, very much so. And I think that more to the harm, again, you know, at the time that recording was made, there was no litigation in sight. There was no attorneys involved. It was simply, hey, we thought we were good to go. What happened? Oh, yeah, I can't use you guys because I was told I'm not allowed. So ultimately, that's our position. I won't belabor this any longer. Thanks.
Thank you very much, counsel. We appreciate the argument and the briefing, and this matter is submitted. We are next up to item number 18 on the docket, and it's now the 11 o'clock docket at 12:17. Could we take a very brief break? All right, thanks. We'll be right back.
All right.
Okay, we are up to item number 18 on the docket, and this is docket number 372782, Blackwell versus City of Inkster. Fantastic. We will wait to see the photo. There we go. Good Good afternoon.
Good afternoon, Your Honors. May it please this most honorable court, Justin Andrews, P 81445 on behalf of the city of Inkster.
You can proceed when ready, counsel.
Thank you very much, Your Honors. We rely on the contents of our brief, but just to touch upon a few things contained within that brief, it should be noted that the public comments for the city of Inkster has been modified to where from this time of the Pele filing, Pele having this matter heard in the district, or excuse me, in the circuit court, that we have amended that public policy or public comment policy to where if it is submitted within 72 hours prior to city council meeting, that it would be distributed to city officials for the purposes of their edification.
Right, but not read out loud.
But not read out loud. No, that not read out loud.
That's a material difference from if the individual was present to make that comment. Is that correct?
That is correct. So we encourage all of our residents, all residents across the state, whomever, to attend the meeting in person to make their comments publicly to the body. One of the arguments made by the appellee was that there was not reasonable accommodation as far as ADA compliance is concerned. That has been shown to be false, as we do have ADA compatible. We are ADA compliant. My humblest apologies.
Well, let me ask you about that because
Yes, Your Honor.
I saw zero admissible evidence from your side in the record. I saw representations made in a brief, but there's nothing. There's no affidavit. There's not a single shred of evidence on your side to support any of those assertions. They're just assertions in a brief. We can't consider them.
Totally understand, Your Honor, but our building is ADA compliant. I can attest for that as a
I get that, but again, the record is absolutely void of any evidence about that. Nothing.
Understood.
And we're Court of Appeals and you can't expand the record here.
I understand that, Your Honor. I understand that 100%. Nonetheless, Your Honor, plaintiff's rights have not been infringed upon. The purpose of the public comment is to disseminate information to city officials about city business and also opinions that may be of a benefit to the city that will help city officials govern the city better.
As I understand it, though, the way it works under Judge Hubbard's injunctive order, his comments have to comply with all the other requirements, limited to 3 minutes, whether there's a requirement that they be germane, whatever the case may be. The only thing that Judge Hubbard does that's different than the policy you have is that somebody has to read the comment out loud, right?
Yes, that was a ruling from Judge Hubbard that the comment be read out loud. And we believe that the way that Judge Hubbard construed that opinion in relation to MCO, so 371102, I believe that is the MCO, which speaks to a disabled person and accommodation for that disabled person, was misconstrued and taken out of context by stating that the public comment was a public service. Public comment is not a public service. The public comment is exactly that, a public comment, and its dissemination to city officials is to put the city on notice, as well as our executive, as to the opinions and concerns of those from the neighborhood who have an issue or may have some sort of issues with the city in and of itself. Those are distributed to city council as well as the mayor for their edification.
Right.
How do I know that's not a service?
Pardon me?
How do I know that's not a service? I mean, you said that's not a public service and you described it, but can you connect those dots for me?
Well, the language of the statute is clear and unambiguous. And when a statute is clear and unambiguous, there should not be any room for.
Well, I guess let me help me understand why it's clear and unambiguous. How do I know that a service doesn't comprise what you just described? How do I know that's not a public service? The public comments from the constituents to their, the representatives and the bodies that are serving them into their community about issues of concern and hopefully improvement to the community. How do I know that's not a public service?
Well, the court may interpret, you may interpret that to be a public service. As far as our position, public service that is not considered public service. Public service is what one does, as far as in law enforcement, as far as in fire. And that's what we believe that the statute interpreted, what the legislative decided for that statute to mean, or the interpretation of that statute to mean, that it being clear and unambiguous in that regard. And we also rely on the opinion from Attorney General Dana Nessel, which has also been articulated in our brief, to where a material alteration would be an undue hardship to the city of Inkster for what the appellee is asking for with regard to a virtual accommodation. This matter has been tested, and is not something that is functionable within our city due to the meetings themselves. If there's a virtual component, there's a significant amount of feedback and things of that nature to where the meeting cannot have this continuity.
But there is a virtual component. People can watch.
They can watch.
They just can't comment.
They cannot comment. And that's what I'm speaking of, is the comment part of it. Because
Right. And what I'm getting concerned about, I think, is the way that you're handling it now. It's not a public comment he's offering. It's in essence a private comment, because it only goes to the people on I think you said the mayor and the members of the council.
Mayor's and a member of the council. That's correct.
Presumably public comment means you stand up in front of everybody and you get to say something, and the elected officials hear it and the people in the gallery hear it. The people in the gallery who show up at the meetings have no idea what he said, right?
They have no idea. They don't have an idea what he said, because it's disseminated to the city officials and the executive for their edification, as I've stated before. And the city of Inkster, like I stated before, has modified our position on the public comment so that those who are not in attendance can have that information presented to the city officials. However, we also, by being, ADA compliant, but I know you said that's not any affidavits that speak to that. Mr. Blackwell, who has been present at our city council meetings numerous times in the past, it still has an opportunity to attend our city council meetings now and state his position publicly to the forum, to the executive, also as well as to the body who are present. And we know that he has that ability to do so because he has done it before, and our building does have the necessity to accommodate him whenever he so chooses to attend our meetings.
Right, but you also have the ability to read his comments out loud because you've done it before. You just stopped doing it after you did it a couple of times, right?
Well, that was under the purview of the council, Your Honor, who made that determination and revised our requirements with regard to the public comment. And we also.
How did the prior practice though impact? I think you mentioned like feedback and things like that.
Yes, Your Honor.
That seems inapplicable if someone who is present in the meeting is reading the comment for Mr. Blackwell.
Yes, that is inapplicable, Your Honor. As far as the request, however, for Mr. Blackwell that we would allow for this virtual component where a person will be able to speak over that virtual component. This is where the feedback would, came into play and would cause issues with the disruption of the meeting.
But to be clear, the order that's being challenged doesn't require a virtual component, correct? It requires
the order
present in the meeting to read the statement out loud.
Yes, but that was a part. But that was a part of the brief.
Understood.
So we were just addressing that. But yes.
So what is the basis for the council's change? Because it obviously is not that it's disruptive over, the internet, because he isn't speaking. He's sending his comments in and they're being read at the meeting. So what?
But the basis for the council's change is, Your Honor, that Mr. Blackwell has attended prior, that Mr. Blackwell has the ability to attend, and that the council should not be saddled by the judiciary with regards to how the legislature intended for the statute to read with regards to the Open Meetings Act. Secondly, Your Honor, we rely on case law in Lysigorski, where we added that to our brief, where it is stated that it's clear from the reading of this provision in its entirety that the legislature intended to grant public bodies the authority to establish and enforce rules regarding public comment as well as the ability to establish and enforce similar rules during hearings and committee reports. And in light Sikorsky, what we do know is that the plaintiff appealed the decision of the trial court, resulting from his inability to make a comment on the record after the time had expired for the public comment. The Court of Appeals upheld the trial court's decision in that particular matter because the trial court, in essence, did not wish to have the city saddled by these type of provisions, and not allowing for the city to regulate its own ability to have rules to enforce public comment. And this is exactly, in essence, what's going on here.
In fairness to Mr. Blackwell, he has a fairly serious disability. And you've pointed several times to the fact that he has shown up in person previously. Did those personal appearances predate his spinal injury?
No, Mr. Blackwell was disabled at that time when he was attending those sessions in court.
What period of time, if you could enlighten me?
This was prior to us taking over as city attorneys of Inkster. So I would say we're looking at the period of I would say at most 2022, 2023. We took over in 2024, and Mr. Blackwell was present during those times at the various meetings, even with, his significant disability. And like I said before, we welcome Mr. Blackwell in person with open arms. We have no issue with Mr. Blackwell attending our meetings and making his statements in person. No, we welcome him with open arms. But when it comes to the submission of the public comment, the city has enacted their position to where, and it's been modified to where within 72 hours of that meeting, providing that comment has been submitted, it will be distributed to the elected officials and also the mayor for their edification. Thank you.
Thank you, counsel. Mr. Blackwell.
Good afternoon, Your Honors. May it please this honorable court, Plaintiff Appellee Charles Blackwell, appearing pro se, appearing remotely via Zoom. Your Honor, Congress and the Michigan legislature has mandated an affirmative obligation on government entities to provide people with disabilities with disability accommodations. This is a novel first impression issue that has never been decided in the state of Michigan before. Your Honors, the city of Inkster change in policy is pure gamesmanship. Let me explain. The record in this case shows that at the June 17th, 2024 City Council meeting, the June 27th, 2024 City Council meeting, that the city of Inkster publicly and verbally read my public comment out loud without any problems. Out of thin air, at the July 1st City Council meeting, they adopted this in-person policy. So literally within the matter of 4 days from June 27th meeting to the July 1st meeting, they went from reading my public comment to saying, hey, in person only. The reason being for that is because the city of Inkster officials dislike my critical comments. If I were saying glowing, flattering things about the city of Inkster, they would have not appealed this order, refusing and balking at reading my public comment. Now, Your Honor, the standard of review is highly dispositive in this case. As this court is well aware, for injunctive orders, this court must affirm as long as the trial court's decision is within the range of reasonable and principled outcomes. As the record in this case reflects, Your Honor, the city of Inkster broadcast their city council meetings via Zoom, but they don't allow members of the public to make public comment via Zoom. So they don't want to allow me to make the public comment myself via Zoom. The record in this case reflects in the trial court's opinion in order that the city of Inkster has outright refused to allow me to make the public comment myself via telephone at city council meetings. So they don't want to allow me to make the public comment myself via Zoom. They don't want to allow me to make the public comment myself via telephone. So A reasonable alternative is what the trial court ordered in this case, which is simply what the city of Inkster had already done prior to this lawsuit even being filed.
Any question?
Mr. Blackwell, I do have one question. They've made a great deal about how you've been to city council meetings and the building is ADA compliant. Now, I've indicated I have concerns about that because there's nothing in the record that we could consider as evidence, but would you like to comment on that, please?
Yes, yes, Your Honor. So, Your Honor, as this court can probably imagine, a person who has been shot and paralyzed can't walk, can't stand, can't drive. And so it's not like I have my own means of driving to a city council meeting or anything. As this court can imagine, my entire daily life is dependent on assistance from others for all major life activities in my life. Now, as it relates to the city of Inkster argument that their building is ADA compliant, a government building can still be ADA compliant and a person still having hardship by needing to have to attend this ADA compliant building. Let me give this court an example. As this court can probably imagine, a person who is paralyzed suffers from, different health ailments, whether it be bed sores because you are always confined to a wheelchair. As this court can probably imagine, a person who has been shot and paralyzed suffers from bladder issues, urological issues. And so it would present a hardship even going to a ADA compliant building if this court were to accept that argument without any evidence in the record that a person could still, suffer hardship by having to attend a ADA compliant building. It would be the example of if a person has cancer and due to their chemo treatment that, with a weak immune system, it might not be feasible for them to have to go to a city council meeting, even though that the building is ADA compliant. And so that they ask the city council for accommodation to submit over their public comment due to their weak immune system from the chemo treatment. So I don't think that a ADA compliant building matters much at all.
Thank you, Mr. Blackwell. That's the only question I have.
Any questions, Mr. Paul?
No, I understand. Very well presented, Mr. Blackwell.
Thank you. Anything else you want to add before we hear some rebuttal, Mr. Blackwell? I noticed you put yourself on mute.
I'm done. Thank you.
Okay, thank you. Rebuttal?
Taking into consideration the opinion of Attorney General Daniels, February 22nd, 2022, with relation to the Open Meetings Act, as well as the accommodation of disabled persons, and determining the reasonable modification as far as accommodation to those individuals. And we believe that our position is that we have reasonably accommodated Mr. Blackwell as far as his comments that he presents to the city for those to be given to individuals who actually can make a difference and actually make change with regard to the various things that he submits to the city. Those are the individuals who are in the position of influence to enact those various things that he expresses his concerns about. So that's our position.
Thank you.
Thank you very much. Thank you both. This matter will be submitted. Moving right along to item number 19 on the docket number 373117, Ian Alexis versus Dante Cerrone. Good afternoon.
Good afternoon. Excuse me, may it please the court?
Yes.
Good afternoon, Kevin Bacon on behalf of the defendant Cerrone.
Good afternoon, Mr. Bacon. We'll have you sit back and listen, and opposing counsel will get right underway.
Hi, good afternoon. May it please the court, Keith Banka appearing on behalf of the plaintiff appellant Ian Alexis in this matter. The trial court here held that Mr. Alexis was not an invitee on the private premises because he wasn't there for the pecuniary gain or the commercial business purpose of the owner of the premises. It based this decision on the Supreme Court opinion in Stitt v. Holland Abundant Life. However, the reliance on that language was misplaced because this is not a Stitt situation. In Stitt, the court or the Supreme Court dealt with
It's a volunteer.
Well,
At a church, right?
yes, yeah, and it dealt with the situation where land is held open to the public, and someone is on that land. Are they invitee or are they a licensee? The Supreme Court adopted the business visitor analysis from the restatement. Now that in those circumstances, the person has to be on the premises for the business's pecuniary gain or commercial purpose. Well, in doing so, in adopting the business visitor analysis, there's a second subset of business visitors, and that's what applies in this situation. And that's in situations where the land is private and someone is on the land for their commercial benefit. And if you look at the restatement, the focus shifts from the defendant's purpose to the plaintiff's. And the two classes of business visitors in the restatement are ones addressed in Stitt, where land is open to the public, but someone isn't necessarily there for a commercial purpose. And then you have the other set of business visitors, which are people on private property doing business.
The theory behind the special duty owed to invitees is you know they're coming, you've invited them onto the premises, and so you have a responsibility to make the premises safe. The way that I hear you explaining this case, it sounds like if somebody shows up unsolicited at your door to try to sell you something, even if you have a sign that says no solicitations, they would be in the position of an invitee.
I disagree. And that's not what I'm arguing at all.
Okay. I mean, this is a delivery person, right?
Yeah, but it wasn't, in a sense, it wasn't unsolicited. He was paid to be there by someone else who wasn't.
Right. But the solicitor's paid by somebody to go to the door and try to get you to buy something.
But there's no beneficial interest conveyed on the premises owner, right?
Maybe there is. Maybe the premises owner wants to buy whatever.
Well, and as soon as they buy something, then that person might transform from a licensee to an invitee once there's that commercial transaction. Right. Here, the commercial transactions happens before the delivery person shows up, and he was hired to be there.
But it's not with the owner of the land.
Oh, I understand that.
So, I mean, if you're arguing for an invitee, presumably there has to be an invitation. So when
it can be implied.
When did the defendant implicitly or explicitly invite your client onto his property?
It's implied by having his land open for
There's
deliveries.
a license. We all know there's an implied license for somebody to come on and knock on your door. But that doesn't make you an invitee.
Yes, but there's a commercial purpose here. And the
For
commercial.
whom?
Not for the landowner.
Oh, yes.
No, his daughter.
Yes, but he gained a benefit from the delivery.
Okay, let's try this. One of the ways that people are trying to terrify judges now is to have pizzas delivered to their house in the name of the deceased son of federal Judge Salas. Somebody orders that pizza. Somebody pays for that pizza. The pizza delivery man shows up having no idea that the reason he's there is to terrify the judge who lives there. That pizza delivery guy's an invitee.
If the pizza is accepted by the judge and the judge goes, "Oh, hey, pizza, I want a pizza right now." If the judge is like, "What the heck is going on? Why is someone," and says, "Get out of here."
So are you saying that the interaction that goes on at the door determines whether somebody's an invitee or a licensee?
It certainly does in the context of Girl Scout cookies, right?
What if nobody comes to the door? What if the person just shows up to deliver a pizza, falls down the stairs with nobody answering the door? How do we know whether they're an invitee or a licensee then? There's no commercial relationship between the property owner and the pizza delivery guy.
Then we would rely on the testimony of the property owner who said, "Well, I didn't order pizza. I wasn't expecting it. I wouldn't have accepted it if it showed up." Here we have the testimony of the homeowner who said, I accepted the cookies. I hold my home open for deliveries. And the problem with the analysis.
When did he say I guess it seems like you're trying to make this after the fact invitation based on what happened after your client entered his premises to provide
Absolutely
The benefit
not.
he didn't ask for.
Absolutely not.
Well, then-
There's an implied invitation by holding your home open for the delivery.
Is what supports that proposition that everybody has held their home open for a unsolicited delivery such that they are inviting them onto their premises?
This would be the White v. Badalamenti, I believe, case where the court
A
looked
mutual
at,
exchange of benefit there, right? A mutual exchange,
but there was a mutual exchange of benefit here.
solicited mutual exchange, an agreement.
But he still received the cookies and accepted them. That is a benefit paid to the homeowner. That is something he didn't have to pay to get the cookies. He didn't have to arrange for delivery himself.
You will
And-
not convince me that this homeowner derived a benefit when godparents are sending his daughter, who broke her arm, cookies.
He didn't have to go pick it up himself. He didn't have to spend time or money to accept a
He
delivery,
had nothing to do with it.
but he still
other than
accepted
opening
it.
The door.
And the problem with the analysis, that's narrow tailoring of the analysis is, what if someone, furnace blows out? I call my dad, furnace blows out. I'm a young homeowner. My dad calls up the furnace guy. Furnace guy shows up. Is that guy going to be an invitee or a licensee? And if you look at the analysis that was done by the court, looking at the
You called your father, who then called a furnace person.
Yeah.
So I guess where's the call from the homeowner to the godparents to say, hey, she'd really like some cookies?
But I don't think that's a meaningful distinction. I think because the solicitation
That's
didn't
where
come
the
from.
problem lies, counsel, because we see it as an important distinction.
But then you get into another analysis, and I point this out in the brief. How do you treat mail carriers? Right? Are we going to look at what that mail carrier delivers on a daily basis to determine whether or not he's an invitee or a licensee at a particular moment? Because mail carriers often deliver unsolicited junk mail. In fact,
That's
now
a matter of course, right? I mean, your mail gets delivered every day. But I think there's a much stronger, I mean, I know you pointed to some unpublished authority that's kind of assumed invitee status. But, it seems like there's a much stronger argument for an implied invitation for regular mail delivery that happens as a matter of course than just a delivery that may not happen, you don't have any reason to expect.
Amazon deliveries are a matter of course now.
Well, you place those orders.
I understand that, but
Right,
they
so I
still,
placed that
but
order and then I
delivery,
didn't
people coming to your home is expected and understood now to make deliveries.
But the whole distinction between an invitee and a licensee is, an invitee is coming. You have the ability to prepare the premises. How in the world was the homeowner here supposed to prepare the premises, go out and shovel, put ice down? You had no idea anybody's coming.
Well, the mailman was coming.
Right, but the mailman didn't get hurt. You're breaking.
I understand, but
you're
he
breaking-
would have expected the mailman to be there.
Right, but you're
And if he's an
breaking the
invitee-
relationship between the invitee and the reason that the property owner has to make the premises safe. I'm sorry, the only reason I'm upset right now is you just kept talking over me, and that's not how oral argument works.
I apologize.
Now, the whole logic of the special relationship and the duty to keep the premises safe depends upon the fact that the homeowner knows someone's coming. The homeowner knows the mail deliverer is coming every day. Homeowner had no idea that this person. How could they make the premises safe?
I disagree.
Why would they?
I disagree with that analysis. And this gets back to the implied invitation. When you have an implied invitation, there's no specific schedule for someone to come by. And just the act of holding your home open for delivery people, that whoever ordered, right? And if you're accepting that delivery at the moment that you're given and you accept the delivery, a commercial transaction has been completed, even though you didn't pay for that delivery person or the cookies, even in this case.
Well,
but there is a commercial
voluntary transaction in the sense that Stitt said a volunteer, tough luck.
Your Honor, can I ask for the same courtesy that you just asked?
Right.
Thank you. But there's a
That's not
commercial.
how it
That's not how it works, but
It isn't
okay.
how it works, counsel.
There is a commercial purpose.
Excuse me. We're gonna exhale and start again. We appreciate that you have prepared for today. But we asked the questions, and there is a requirement that you give us deference. We will do everything we can to reciprocate, but you don't come here and lecture the Court of Appeals.
Apologies, Your Honor.
Thank you. So anything else you would like to indicate for the record, you will have time for rebuttal.
I will just leave it with what the restatement says about this class of business visitors. And what the restatement says is the second class includes those who come upon the land not open to the public for a purpose connected with their own business, which is connected with any purpose, business or otherwise, for which the possessor uses a land. And under that definition, Mr. Alexis does qualify as a business visitor entitled to the protection of an invitee.
Thank you.
Thank
You
you.
have time for rebuttal? Mr. Bacon.
Thank you, Your Honor. I will be very, very brief and rely primarily on my briefing. I will just address one issue that came up on oral argument that I didn't directly address in the brief, and that is the issue of the mailbox. Just so this court is aware, this incident occurred on the stairs to the front door of the home. In this case, the home is on a long driveway set back off of the road, and the mailbox is actually at the end of the driveway. So the statement that the mailbox or that the mailman would have somehow gone to the front door is inaccurate, as the mail would have been delivered to the end of the driveway. It never would have made it to the house. In addition, the facts of this case are pretty clear that the defendant was out of town for several days before. And while we've all done this, we go on vacation and we can stop our mail while we're gone. So there would be no anticipation that the mailman is going to come because, one, we would stop it. Two, you would be to the end of the driveway, not to the front door. And otherwise, I rest on my brief. Thank you.
No, thank you.
No questions. Thank you. You have time for rebuttal, counsel.
You know, this court has brought up the idea of, you know, when the invitation came, and I cite an Oregon Supreme Court opinion, and they found an implied invitation under these circumstances because of the nature of delivery services and whatnot. So I don't think it's absurd that I'm up here arguing that there was an implied invitation or that Mr. Alexis should be considered an invitee.
Well, and I think the issue of the different stratifications is obviously like a very live one. And I believe there's an application pending in the Michigan Supreme Court. They're considering, you know, do we rethink fundamentally how we do our duties in terms of like premises liability and all that sort of stuff? So yeah, no, it's very interesting intellectual stuff.
Oh, and I intend, if I do get an unfavorable opinion, to challenge it in the Supreme Court, you know, so, but I understand this court's position, and, you know, I apologize for earlier.
No, it's fine. It's fine. Please don't worry.
And congratulations on your retirement,
thank you.
and I hope you enjoy that, and
Thanks.
rather than having to deal with people like me, so.
No offense taken, and thank you so much. Mr.
You're
Bacon.
welcome.
Really appreciate it.
So, thank you both. This matter will be submitted. Moving on to item number 20 on our docket, and this is docket number 373230, the State of Charles Holmes versus CCLA 9 LLC. And I believe we have some participants by way of Zoom. Mr. Falk, we saw there you are. Good afternoon.
Good afternoon. May it please the court, Alan Falk on behalf of Loretta Hobbs, personal representative of the estate of Charles Holmes, deceased. At the outset, I'll join others in congratulating Judge Yates on retiring. I'm pretty sure I'm quite a bit older than, for sure I'm quite a bit older than you. And,
I'm older than I look, but thank you, Mr. Falk. That's very kind of you.
I'm sure I got at least a decade on you, but anyway, enjoy.
Yeah, thank you so much.
I wish you all the very best. You know, I know you've read the briefs, and I won't spend any time going over them other than to just briefly, because you have some 20 cases on your docket today, make sure we're all talking about the same case. My guy went to Riverview Clinic for post-COVID treatment after he was cured of COVID at a hospital. So by the time he got to Riverview, he didn't have COVID. Everybody agrees on that.
He tested
And
negative.
one of the treatments they gave him was to put a heating pad on his legs, and somebody didn't attend to it, and he got severe burns. I think they're probably second-degree burns. The photographs are in the record and were attached to my brief. And the wounds are ugly. More than a year later, Mr. Holmes died of unrelated causes. So this is, just a suit for damages, not wrongful death.
Right. And Mr. Falk, I think this is one of those areas where we've written a lot and published opinions on this. Would you tell us which of the 3 published opinions from our court you think applies? And by that, I mean Franklin or Skipper Baines or whatever the third one is. I'm embarrassed.
Joe Keenan, Your
I
Honor.
wrote the third one, Joe Keenan, but I can't remember the title of it. Yeah. Why don't you fit it into one of those 3?
Certainly.
Because it seems to me that the lines are pretty clear now.
Yeah. So of the 3 published cases, this is pretty much like either Skipper Baines or Joe Keenan, both of which this court says, well, when the person is not being treated for COVID, pretty much the public or the Pandemic Healthcare Immunity Act just doesn't apply because of its phrasing that says, you get immunity for when you're a healthcare facility that provides support for this state's response to the COVID pandemic, and the injuries arise from the services, from those particular services. Well, since Mr. Henderson received no COVID-related services by these 2 defendants, the statute simply doesn't apply, as those 2 cases say. That third case, you referred to it as Franklin, but it's actually Warren. The plaintiff's name in that case is Franklin Warren. I don't know why people keep calling it the Franklin case, but I believe it's the Warren case.
Sorry.
But I mean, his name could be Warren Franklin, and maybe I have it backwards, but I thought it was Franklin Warren. So does that answer your question of which of the 3 published cases, I believe are most applicable and why?
Yes, it does. And I think you have a due process argument as a fallback position too, right?
Well, that had to do, yes, with the retroactivity problem of section 1477, MCL 691.1477.
Right. But that statute is, by its terms, retroactively applicable. I would think that to the extent that you want to challenge it, you have to challenge it on constitutional grounds.
Correct.
Because by its terms, it's retroactive.
Yes, yeah, there's no quite right. The first question with retroactivity always is, well, should we construe the statute as retroactive? But here there's no doubt. The legislature made it abundantly clear that's what they wanted to do, although they did it for this weird period of March 9th to July, to the middle of July, which I think is an equal protection problem. But, that aside, they can't, my client had a vested right to file a common law malpractice action by the time the statute was enacted in October, which is long after the events in question here. So you can't be taking away somebody's vested right to sue, by a series of U.S. Supreme Court and Michigan Supreme Court decisions, is a deprivation of property without due process of law. It's pretty straightforward. I will admit, and I'm a big opponent of citing unpublished cases when published cases exist, but I had another case in which the court, without anybody ever raising the issue, said that because the governor had issued executive orders in April of 2020, which is when my events occurred also, that those executive orders bestowed immunity, and therefore there's no retroactivity problem. Well, there's several problems with that analysis. First, the governor doesn't have any authority to grant immunity, but under the Emergency Management Act, the governor's declaration of an emergency creates immunity for 28 days, and then that time can be extended if the legislature passes a joint resolution extending the declaration.
Counsel, sorry to interrupt, but did you brief any of this?
No, but I didn't, but it wasn't briefed in the previous case either, and it was sprung on me. So I'm trying to avoid another surprise. If the court has no intention of going down that road, I'll stop talking about that.
Could I take us back to Skipper Baines because I was on that panel?
Certainly.
And as you know, the distinction there was that the allegation of negligence and malpractice was, and I'm quoting now, quote, wholly unrelated to the pandemic. And I know you have argued, and I don't believe it's disputed, your client tested negative for COVID-19 prior to being taken to the rehab center. My question is, though, wasn't the stop at the rehabilitation center necessitated by the COVID that he had endured previously?
Yes.
Okay.
Yeah, he was left weakened by the COVID, and so that was one of the reasons.
Yeah, that's if you can parse that out then, because that seems a distinction from Skipper Baines.
I won't disagree with Your Honor that it is a distinction, and I will be happy to address that. So, yeah, he's weakened by COVID. He has some other things that they're also treating him for. So, but weakness from COVID is certainly one of them. But the thing is, as far as we know, and as far as the record shows, Riverview and Therapy Management don't treat actual COVID patients. So they're not providing services in response to this state's declaration of a pandemic.
Okay.
So, my client is just like anybody else who happens to have some kind of serious, medical weakness, and he needs some kind of inpatient therapy, right? It doesn't, the fact that it was caused by COVID or a car accident or anything else just has sort of nothing to do with it. He's just a weak guy, and that what these people do is therapy for people who are weak. So, he's in the right place for that kind of treatment.
Thank you.
But I will say in their briefs, both defendants allege that they're providing COVID-related services, but there's nothing in the record to support that. And they're the ones who moved for summary disposition and had the opportunity at the time to produce, whatever evidence they had. And there simply is none in the record, just the statements of counsel. And in an earlier argument today, I heard a member of the panel say, wait, this is just things that people are saying in briefs. It's not evidence in the record. So
that's true.
I know you're fully aware of that, and I won't beat that one to death any further. So that leaves the secondary defense, which is applicable technically only to Riverview, although Therapy Management has also raised it, which is the PrEP Act, that federal statute. But when you examine the statute, it's pretty clear how it operates. It says you're immune if you're using a covered countermeasure to treat a declared pandemic. So in this case, the Secretary of Health and Human Services did declare a pandemic, and that made the act applicable at the relevant time. But the heating pad is not a covered countermeasure. The definition of a covered countermeasure, you have to go through a series of statutory provisions to figure it out. But a covered countermeasure is something that's specific to treating a pandemic. So, and when it comes to devices, it's all about experimental devices. It talks about devices that are investigative or experimental. So, for example, Yale Medical School early in the pandemic figured out a way to use a respirator on 3 patients instead of only 1, which was hugely helpful when lots of patients needed respirators and there weren't that many in the entire country. And so if as a result of using this new experimental device, somebody was injured, the PrEP Act would give them immunity from the use of that, from injury resulting from the use of that device. But here, the heating pad is not an investigative or experimental device for treating pandemics. It's just, it's an electric blanket. There's nothing experimental, investigative about it, nothing specific about it for treating pandemics, as opposed to, a vaccine or, something else that's specific to the pandemic. So the whole idea of the PrEP Act was if you use an experimental drug, if some people, I remember at the time people were using, ivermectin,
horse dewormer.
The horse dewormer. But now we have Paxlovid. But when Paxlovid was first developed and utilized for this purpose, I'm sure was experimental. It got some kind of emergency approval by the FDA.
I think we understand the argument, and I appreciate the explanation regarding the applicability of Skipper Baines. I'm going to look to my colleagues and see if they have any more questions to pose. It's no? Okay. Anything else you'd like to indicate, or shall we save a few minutes for rebuttal?
I have nothing further to add. I will save my remaining time for rebuttal. Thank you, Your Honor.
Okay, thank you so much. And we have two lawyers here. Are you each arguing?
Yes, Your Honor.
Okay, and are you dividing your time then?
Equally, Your Honor.
Equally, right. You can proceed.
Good afternoon, Your Honors. Catherine Gossick on behalf of Defendant Riverview. I'm going to try to be short since everything has been briefed. With respect to the COVID-related services, I have read the Pandemic Healthcare Immunity Act maybe hundreds of times by now. Nothing in there narrows liability, immunity to COVID treatment. And nothing in there says that someone has to have an active COVID diagnosis for immunity to apply. And in fact, at that time, there was no actual treatment of COVID-19. It was all treatment of symptoms that were caused by COVID-19, fever, pneumonia, cardiac issues. There's no actual COVID treatment. Here, Mr. Holmes was sent to Riverview for treatment of his COVID symptoms. He tested negative, but he still had residual symptoms. He was in the ICU for over a month. COVID wrecked his body. He was there for rehab services to deal with his residual COVID treatments. That is the connection between COVID and immunity here.
So under your theory then, and I know that there's a time frame on immunity, but if there were no time frame on immunity, if somebody were suffering from long COVID, their providers would be given immunity from now till the end of time.
Yes, Your Honor, but I think there's a reason why there was a small limit on the time frame of it.
I get it, right. My hypothetical was
Yes.
somewhat inaccurate in the sense that this is a closed-ended grant.
Correct, Your Honor. And that actually goes to the second point with respect to constitutionality. Plaintiff's counsel mentioned that the dates are arbitrary with respect to the immunity period, but they're precisely decided based on the executive orders. Executive Order 2020-30 was signed by the governor on March 29, 2020. It has a nearly identical immunity provision as the Pandemic Healthcare Immunity Act.
Would you like to deal with the point Mr. Falk made about the complication of the order from the governor first, and then the statutory immunity protection coming in after the fact to essentially bless what had been done by the governor earlier?
Yes, Your Honor. It essentially codified what the governor has done. And the governor did have the authority at that time to enact those executive orders. There was a Supreme Court decision later on, but that was for things that occurred after a certain date. They did say that the governor had authority at the beginning.
Right, because in the ordinary course of things, a governor wouldn't have the power to grant immunity in this way.
Correct, Your Honor.
I mean, I know it's emergency powers.
Yes, Your Honor. And that's why Executive Order 2020-30 was enacted on March 29th when there was a state of emergency and a state of disaster in place.
So just to be clear then, as far as retroactivity of the statutory immunity goes, your view is that was really belt and suspenders, but it wasn't necessary. The governor's executive order would have been sufficient in and of itself to confer the immunity that you're seeking?
Correct, Your Honor. And it also goes to the vested issue. There was no vested right at the time of March 29th, 2020. There was an executive order providing immunity. So any
claim that has yet to accrue has not accrued because there was that availability of immunity at that time. There's an unpublished decision that recently came out that discusses this. It's
But I guess counsel, I'll ask the same question, just in fairness. I mean, was this briefed?
Yes, Your Honor. I talk about vesting at, I didn't mention the new published case, 'cause that was unpublished case, 'cause that happened in December. But it was briefed that the right was not
Was not
vested.
vested.
Yes, Your Honor.
Anything else you'd care to add before passing the baton, counsel?
Nope, unless this court has any questions. Thank you.
Thank you.
Thank you.
Good afternoon, Your Honors. Andrew Malik on behalf of Defendant Therapy Management. I will similarly keep it brief. I know all of the issues have been briefed very thoroughly, and some of the arguments between Riverview Health and Therapy Management are very identical. So I will just like to emphasize again that the entire reason for the care being transferred to Therapy Management, which provided physical therapy and occupational therapy services to Mr. Holmes, was that initial COVID diagnosis. So in terms of the treatment that's being provided to him, it all stemmed from that COVID diagnosis at DMC Hospital. And then as far as the published case law, I do think that this case falls squarely in Warren. And I do think, as Your Honor has mentioned, Skipper Baines actually is very instructive on this case as well. There is that connection to COVID-19, which is why all of the other treatment transpired with respect to Mr. Holmes' weakness and mobility issues that he experienced thereafter. Otherwise, I think I will rely on my brief unless there are any other specific questions to Therapy Management specifically. But I do think all the arguments have been addressed, and I don't want to keep repeating the same sorts of things over and over.
Any further questions?
No, thank you.
Nothing more from me.
Thank you very much, counsel. Mr. Falk, last word.
Thank you, Your Honor. A couple of quick things. First, under Article 3, Section 7 of the Michigan Constitution in 1963, the legislature and the judiciary can change the common law. The governor can't. So the governor can't grant anybody immunity from civil liability, period. Under the Emergency Management Act, MCL 31.411, the governor's declaration of emergency has the effect of bestowing immunity. But neither one of our present defendants relied on that statute in moving for summary disposition. So that's point one. Point two would be that even if they did, the Emergency Management Act says that the governor's declaration of emergency is only good for 28 days. And when the legislature, and that expired before my guy was injured. So that's number one. So which creates the retroactivity problem I'm elsewhere talking about. Furthermore, the governor's declaration of emergency was extended by the legislature by a joint resolution, but between March 29th and April 30th, the resolution wasn't in effect. The resolution didn't occur until Senate Journal of April 30th, 2020, when the Senate forwarded the joint resolution after agreement by the House for filing. So there was, during the critical date when my guy was injured, the resolution was in effect. But even if the resolution was in effect, under Blank versus Department of Corrections, a resolution can't extend something like that. Blank versus Department of Corrections involved the Administrative Procedure Act, where the legislature could by resolution cancel an administrative regulation. And the Supreme Court said, no, you can't. The legislature can only operate by passing acts or bills. There's got to be, a bill filed, 3 readings, vote by each house, signature by the governor, or overriding a gubernatorial veto. You can't circumvent that by passing resolutions that don't go through all these processes, presentment, and all kinds of other things. So, that way of getting around retroactivity just doesn't work.
So in other words, if the legislature wants to confer immunity by public act, it may do so prospectively, but not retroactively.
Correct.
Okay.
And then the last thing I would want to say is that, contrary to what Counsel for Therapy Management says, the treatment of Mr. Henderson, or I'm sorry, of Mr. Holmes doesn't arise from a COVID diagnosis. Because specifically upon admission, the record says, not suffering from COVID. So, we just have a guy who's got some weakness from something that happened previously, which happens to be COVID in part and other medical conditions in part. But that's not a diagnosis of COVID leading to this therapy. It's quite the opposite, the antithesis of that. So with that, I will rest unless you have any further questions for me.
I think we understand.
Yeah, thank you, Mr. Falk. No,
Thank you
no more
all.
questions.
Thank you and good luck, Judge Yates.
All right, thank you. This matter will be submitted. We're up to number 21 on the docket, which is docket number 375171 in Ray KT McKee Minor. Mr. Walton, the last one standing in the room.
Thank you for being here, by the way.
Yes.
People never show up in these cases, and it's really nice to hear somebody actually care and show up and make an argument.
Appreciate that. Good afternoon, Matt Walton on behalf of DeWanda Harrell, who's a mother who recently had her child's parental rights terminated. This case started when she got pulled over for drunk driving and the child was in the car. She has pre-existing mental health issues. She's bipolar and schizophrenic. And the worker, Veronica Chapman, said, most importantly, mother's treatment plan, mental health services should be focused on substance abuse. Mother may have been bipolar and schizophrenic, and she, meaning the worker, is not able to provide special services for her. So mother, schizophrenic and bipolar, the worker is not able to provide specialized services for her. During the course of this case, which started in 2022, at one of the court hearings, she tells her lawyer, she's on the stand, that she just had a child die. And she explains a little bit about it. And the worker, or the attorney rather, says, my condolences. But that issue is not dealt with by the worker, by the court at all. She makes a statement, a child died. Now, the AG in their response brief says she had a preemie and the baby subsequently died. So I guess our first argument is that she wasn't provided with the services that she should have been. She's schizophrenic, she's bipolar. The worker says, I'm not able to provide her with the specialized services she needs. Okay. The second issue that, this is a service issue. It appears that mother was never personally served with the permanent custody petition. It's unclear to me because I couldn't find the proof of service. And it's addressed by the AG in their page 13 of their reply.
Is it true that during the hearing itself, she somehow called her lawyer?
Yes.
And they had a conversation and the lawyer said on the record, she knows there's a hearing today?
That's the January 29th trial date. And yes, that is what happened. And I don't know what that means. I mean, that he left a message, she called and said, okay, I'll try to be there. I don't know what it means. He offered to make her available. I think it was later on in the hearing and the court declined that. And when she was last in court on 10/17, the court gave a trial date of February 14th. And it was very clear, it's on the record, we'll see on February 14th. For some reason, there was a trial on January 29th, I think. So the trial got backed up a little bit.
I thought it got moved up. It's a very strange situation. I thought the original notice she got said February and then they moved it up to the 29th.
Right. Yes, that's right. And so I don't know that she got notice of that. It appears that from the AG's brief that they attempted personal service, they attempted certified mail, and that the court did get proof of publication on January 15th, and that was requested on January 2nd. I don't know if that date was moved up before publication was ordered. I think it's the AG's burden to show that the person has been properly served.
Well, and maybe I'm getting confused about which date this was notice of, but I think a summons dated January 8th, 2025 indicates that respondent was personally served on that day. Are you saying that she was served on that day and given notice of the February date or the January 29th date?
I'm sorry, I'm not sure I understood your question.
Well, there's a summons that indicates that there was personal service accomplished. The summons bears the date January 8th, 2025. That's how you track it down. It includes proof of personal service. And what I'm wondering, and maybe you don't know this, and maybe I'll have to just look in the record about whether that summons that was personally served on her gave her notice of a hearing in February or a hearing on January 29th, which was the subsequent date established.
My understanding, it was the February date. She remembered it because it was Valentine's Day. And that for some reason it got moved back.
Okay.
And the date of, at the trial date, the referee says she was served today. Now that's kind of strange. I don't know what he means by that, but that is in page 3 of my brief. Says she was here the last. Today is a date and time. All right, thank you. Well, mother was here at the last hearing, was served a copy of the petition she knew about today's date. And I'm sorry, above that. Mother was served with a copy of the petition in court today. That's page 5 of the trial transcript. I'm not sure exactly what that means, but she wasn't at the trial. She tried to connect later during the trial by phone and was.
Right, that's when she called her lawyer.
Correct.
Reported to the court that she was on the phone.
Right. And then the last issue, of course, is that with the best interest analysis, there are no specific findings made. I think the law requires that. And instead, we just have a statement that is given verbally as well as in writing that that it's in the best interest of the kids to terminate their rights. Our child, I should say. Yeah.
Any questions? All right, thank you very much, counsel. And again, thank you for caring and appearing. It helps the panel with.
Oh, I really appreciate it. Thank you. I'm nervous, as you can imagine. Can I ask a kind of a stupid question with respect to the prior case?
Oh, the one that was argued earlier?
Yeah, the gun case.
Yeah.
You had asked me whether there was a ladder, chair or something, and I said I understood it to be up high. I don't know about a ladder chair.
Okay.
I'm not sure why I thought it was up high, but I don't want
No,
to
no,
mislead you.
please don't worry about that. I certainly didn't take it as a factual representation that might be inaccurate.
Well, thank you very much. Have a good
Thank
day.
you. Have a lovely day. This matter will be submitted and we are now up to item 22, docket number 374386. And this is In Ray Beverly / Richardson Minors. And I will profess that I do see there that we did grant argument to Ms. Gilfix, but do we have, no one's checked in? Okay, then this matter will be submitted. And then finally, last but not least, this is item number 23 on the docket number 376388 In Ray O'Haver Minors. And this matter, no one is endorsed, so it will be submitted on briefs. And we got through the day, gentlemen. So Let's call it.
Well done.
Thank
Madam
you.
Presiding Judge.
Court is concluded.